Item 40 for judgment delivery.
In view of what has been discussed here and above, this court is of the considered view that for determination of compensation for acquisition of the right of user on land under PNMP Act 1962, the provisions and methodology under the Right to Fair Compensation Act 2013 would apply by virtue of the Right to Fair Compensation and Transparency in Removal of Difficulties Order 2015, which explicitly bringing with the sweep of determination of compensation under PNMP Act 1962 by applying the provision of Right to Fair Compensation Act 2002. Accordingly, competent authority is directed to determine the compensation in accordance with the provisions of Right to Fair Compensation Act 2013, particularly solicium and interest. Consequently, the impugned judgment of the learned additional district judge and the order dated 07/08/2026 passed by the competent authority are set aside. Writ petition accordingly allowed.
Mention.
Make with the lordship, my lord.
Yes.
I beg to mention item number 39, lordship.
Hmm.
I have a due consent from the other side. I need 2 weeks time, but my lord, it was showing as hearing, lordship, but it's not yet admitted, lordship. So I pray let this matter may come up for admission after vacation, lordship.
Why this has been listed for a hearing?
Hearing, lordship, it was only notice of motion was issued on 28/7/2025
What is the matter about?
regarding NOC next kin issuance of next kin certificate, lordship. They have included one provisions, lordship, that two wife is not entitled for next kin certificate.
You are challenging that.
Lordship. So I need some affidavit, lordship, additional affidavit to establish the things, other documents are there, lordships.
Affidavit has been filed.
Government, all pleadings has been completed.
That's why hearing this is
Lordship,
it's not necessary to formally admit it.
lordship, I pray, lordship, admission hearing, it may come up.
What admission hearing? It's listed for hearing. We'll take it up today.
Lordship, I want to file additional affidavit.
What additional affidavit?
Lordship, the declaration of the family, lordship, there, nobody was there, lordship, except all the two wives and other legal heirs. For that, I need some time, lordship, to file additional affidavit.
No, when you say that, when you are challenging the requirement of requirement that the
Lordship.
two wives should not be entitled for next of the kin certificate, then
Lordship, they have no dispute, lordship at all. They are jointly applied for that. They jointly applied for next kin certificate, lordship. And in the categorical statement is there in one Madras High Court judgment I have referred that since both the parties are agreed, lordship, the state have no role to restrain them, lordship. So because family pension and other things are there, compassionate family pensions are there. For that, lordship, I want to get a declaration from the learned court, lordship, which below, as regards they are the only legal heirs they are, which record I want to produce, lordship, by filing additional affidavit, lordship. So I have a consent from the other side, lordship, let matter come after vacation or hearing or admission, lordship. It should be a hearing, it may not reach, for which I am praying.
I know.
what it is listed for will not.
Lordship, then after vacation, lordship, any day, subject to convenience.
Mr.
K. Majumdar, lordship.
K. Majumdar, counsel for the petitioner submits that you may be granted some time to file affidavit, additional affidavit to bring on record the declaration to the effect that the two wives
Lordship.
are the legal heirs of the deceased
This is husband, lordship.
husband of the deceased husband. list them. Prayers allowed, list the matter after 4 weeks.
Lordship. Item for two.
Yes.
I think acting for 32 for order. We are considering the fictional losses in letter taken out of vacation.
On the prayer of Mr. SMTC learned counsel for the alleged contempt number?
Yes.
Number?
Number 1 and 2 both losses.
Alleged contempt has come, let this matter be listed after 4 weeks.
Yes.
My lord,
That I would like to mention two cases, one can be listed on the Friday.
Why? What is the urgency?
State only 27/4/2020.
27/4,
Today,
2024.
26.
6
And another was is non-payment of salary.
after 2 weeks.
After vacation.
After vacation. There is no urgency.
my lord, if I
So, but, another one is urgency because he did not get the salary.
What salary?
Salary, non-cheaper.
Maximum in this is this bench is dealing with non-payment of salaries only. There is no urgency.
my lord, if I may pray for
I think it's a norm in Assam. It's a norm in Assam not to pay the salaries to the teachers. That's what I'm saying. That's the norms of the state. It has to be norms of the state. Yes,
But they are working, my lord, they have to pay.
that's what I'm saying. It appears to be norms of the state.
my lord, if I may pray for a motion listing tomorrow, my lord.
Where?
The order impugned was issued.
Next week.
My lord,
Next week.
the matter will, there'll be no issue that will survive, my lord. There's a contractual term of 3 years, my lord, where termination for convenience clause and termination for cause.
So what did nothing
No,
remains?
no, my lord.
What withdrawal?
No, my lord.
Yeah.
We have to move the matter, my lord, tomorrow for interim protection, my lord. The interim protection, my lord.
When nothing remains,
No,
why?
day after tomorrow, my lord, nothing will remain, my lord. Tomorrow, my lord. The last date for his service would be, my lord, 18th of June.
Service?
18th.
What service?
My lord, the petitioner was rendered a contractual employment at an education institution, my lord, for 3 years. For 3 years, my lord.
You have
They just-
completed 3 years?
No, my lord. I
Ah.
just finished 1 year.
Hmm.
Unceremoniously, against the terms of the contract, my lord, his service is scheduled to expire on 18th. 18th being a Thursday, which is a hearing day, my lord. I'm praying the matter may kindly be listed tomorrow.
It's going to be expired on 18.
His last day of service is going to be on 18th.
Then?
Beyond that, my lord, there will be no, my lord. He has an additional term of 2 years left as per the terms of the contract. He has been unceremoniously based on some recommendation.
Which post?
My lord, he's a faculty. He's a faculty/designer in National Institute of Design in Jorhat. The term was for 3 years. The term was for 3 years, and thereafter he could have been removed or his term could have been renewed. There was a committee constituted, no notification. The findings have not also been made available to him. Unceremoniously based upon his own presentation, not the APAR. Upon his own presentation, my lord, his term is sought to be curtailed to 1 year, which is going to expire on 18th. 18th being a Thursday, my lord, which is a hearing day. We have filed the matter yesterday. The order was issued on 8th. There's been no delay on our part, my lord. Tomorrow, my lord. We have.
So where is the guarantee that the order will be stayed?
My lord, the terms of the contract mandates, my lord, that there is some ground for your lordship to exercise jurisdiction, subject to what your lordship may finally decide, my lord. That is ours.
Let us see.
I'm grateful. Tomorrow, my lord.
May I please your lordship, my lordship, due to some personal difficulty of senior counsel Mr. H.K. lordship, I pray for an accommodation in item number 5, lordship. Lordship, may kindly, I have already taken consent from the other side, lordship.
Item 5.
Lordship.
2019 matter.
And some recommendation for the date of
On the prayer of Mr.
N.K. Sharma, lordship.
N.K.
Sharma.
Sharma, Learned Counsel. On the ground that Mr. H.K. Das, Learned Senior Counsel
Lordship.
for the petitioner has some personal difficulty today. Come on, let this matter be listed after 4 weeks.
My lord, these matters may be listed on Thursday, my lord.
Why?
My lord. One is for my lord.
Next week, madam, next week.
Next week, a date, my lord.
Next week. Put that in. What is the urgency?
Urgency, my lord, because during the operation of status quo order, my lord, an order was passed by the authority.
Next
whereby-
week. Next week.
May I say?
Yes,
Second, verification.
22. On the prayer of Mr. B. Talukdar, the Standing Council Elementary Education Department. Further 3 weeks' time is granted to file affidavit of his.
May I please, your lordship? Lordship, I beg to mention for listing of all pending writ petition, my lord, on 16, my lord. Last occasion matter was listed on 29/4/2026. This honorable court directed to list the matter after 2 weeks, but are unfortunately.
After vacation.
Matter
After
is urgent,
vacation.
my lord, non-payment of pension, my lord.
After vacation.
Obliged.
Wait, please, your lordship. Let's say with the consent of the other side, I'd like to mention item number 7, your lordship. Maybe on after vacation, your lordship.
Why?
Lordship, have some difficulty on my senior, your lordship.
On the prayer of Mr.
R. Boro, lordship.
Arboro,
Lordship.
learned counsel appearing on behalf of
Petitioner.
Mr.
Petitioner.
C. Borua.
C. Burwa.
C. Borua, learned counsel for the petitioner on the ground that Mr. Borua, learned counsel has some difficulty. Today, let this matter be listed after 4 weeks.
Lordship.
Hmm.
Obliged, your lordship.
May I please, lordship, I beg to mention item number 28, my lord. The matter, we like to withdraw, madam.
20.
Yes, 28, madam, 28.
Mr.
L. Deca,
L. Dekar, learned counsel appearing on behalf of
M. Dotto.
M. Datto, learned counsel for the petitioner. Press for withdrawal of the petition. Please to. Mr. R. R. Sahini. R. Sahini, learned counsel appearing on behalf of Mr. Dina, learned counsel for the respondent 1 and 3 is present, huh? Accordingly, contempt of his estates closed.
Obliged.
Please, lordship. Lordship, I beg to mention item number 2, 3, 4.
On withdrawal, huh? 2, 3,
4.
why?
Lordship, engaged counsel is out of this, under medical treatment.
2017 matter.
Yes, lordship. After vacation,
Vacation, after vacation, you will also know. We'll hear it today. We'll hear you today.
lordship, after vacation.
Your Bora,
Lordship, A does.
MS A does learned counsel appearing on behalf of Mr. P. Talukdar, learned counsel for the petitioners. Submits that Mr. Talukdar, learned counsel has some is indisposed today, therefore press for listing of the matter after 3 weeks.
Yes, lordship.
Christoph. Praise the Lord. However, considering the matter is pending since 2017, the adjournment is granted as a last chance. Last chance.
Yes, lordship. Obliged, lordship.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 6.
6.
Lordship. Here we want to file implement application, Lordship. Implement application we want to file. Elementary education is the necessary party. Here elementary education is not here, so.
On the prayer of MS,
S. Laskar.
S. Laskar, learned counsel appearing on behalf of Mr. A.R. Buya, learned senior counsel for the petition. Let this matter be listed after 4 weeks for filing appropriate application as faithful. List accordingly. List accordingly.
May I please, lordship? Lordship, item 17, 18, and 19, lordship. After vacation, lordship.
Why?
Lordship, today some difficulty, personal difficulty. Other side concern also, lordship. After vacation.
What is the matter about?
Matter, lordship, provincialized of petitioner service, lordship, of grade for employee, lordship.
Provincialization. Yeah, you filed the affidavit.
Elementary.
Elementary education. You have filed. On the prayer of MS,
J. Akhtar.
J. Akhtar, learn counsel for the petitioners. Let this matter be listed after 4 weeks. In the meantime, Mr. P.K. Bora, learned standing counsel elementary education, may file the affidavit in the opposition.
Lordship, I beg to mention item 15 for adjournment, Lordship.
15.
Yes, 1-5, Lordship.
Hmm.
Conducting counsel K. Borua is out of station, Lordship.
On the ground that Mr. K. Borwal learned counsel for the petitioner has some personal difficulty today, comma, MSP Bora,
Lordship, I'm M. Huya.
M. Buya, learned counsel appearing on his behalf, prays for listing of the matter after 3 weeks, prayers are list after 3 weeks.
Wait for listing of an IA tomorrow, your lordship, in the orders column.
Next week.
Uh,
Next week. What is the urgency?
Pertains to the appointment of headmaster and headmistress. The matter is pending before the honorable court tomorrow. There's another, it is connected.
Hmm?
The matter is connected to the writ petition that is listed tomorrow, your lordship.
Then it's okay.
I'm grateful.
One for admission. But here I have exactly the petition has already been expired. And moreover, the prayer, the 10% quota about retire, that has already been abandoned long time. And matter is becoming impersonal. Document can prove this.
Lordship, as per instruction of Mr. B. Paul, conducting counsel of this case, Lordship, there is no contact with the client from since a long time.
He has expired.
Lordship, then Lordship.
I have very copy to him also. The report that is big. And then him. And also it involved abandoned law, it is no more.
You cannot change the destiny.
Lordship.
Well, let's not say anything. You just withdraw. As in process.
Lordship.
No, anyway, we'll just say. Mr.
You push.
U. Ghosh, learned counsel for the petitioner, submits that the writ petition has become infructuous in view of the fact that the petitioner has unfortunately expired during the pendency of this writ petition. Please stop. Next paragraph. The Mr. SMT learned counsel for the learned standing counsel secondary education by placing the communication dated 15/6/2026 from the inspector of schools, BDC Barpeta, submits that with the death certificate of the petitioner, submits that the petitioner has expired on when?
Date 10/9.
10/9/2023.
10/9/2023. Please stop. He submits that the scheme under which the petitioner claims has been already has already been superseded.
It is no longer.
Superseded and no longer no longer been followed by the state. This stuff. Next paragraph. Considered in view of the above, the writ petition. The issue raised in the petition is no longer survived. Is no longer survived. This stuff accordingly, writ petition stands closed.
Lordship, I am appearing on behalf of Mr. B. Paul. My name is not in the list, Lordship. So his name may be reflected. Obliged, Lord.
Then you, after SMT submission, SMT 60, huh? MS B Pukon. K Pukon.
Obliged, Lord.
Item 8.
No, my lord. As per my instruction, my lord, ZPF and group insurance money he has not received, my lord.
Towards the GIS and Provident Fund has not been released.
Lord,
Then you have sought for a time on 24/7. So if everything has been paid, so release then.
no, my lord, even today morning also, my lord, I've contacted my client, my lord. He had clearly stated that, my lord, ZPF person and group insurance person, till that, my lord, he has not received, my lord. Let them show, my lord, before this.
It's particular rest has been received, but the GIS and the Provident Fund.
Lordship.
Are you sure?
Sure, my lord. Let them satisfy this honorable court that, my lord, they have paid, my lord.
What, Mr.
SAB Khabir, my lord.
SAB Kabir,
Khabir, my lord.
Kabir Das,
Khabir, my lord.
learned counsel for the petitioner. Next para. Having considered that the certain amount has been paid and received by the petitioner, but the amount towards the GIS and the Provident Fund has not been released, this court on 24/07/2025 directed Mr. PJ Fukar, learned standing counsel. For what? Element, standing counsel? Huh? Gauhati University to obtain instruction regarding a balance payment to be made to the petitioner. Today, Mr. Fukon, learned standing counsel submits that all the on instruction submits that all the dues, public entitlements have already been paid to the petitioner, to which Mr.
SAB Khabir.
Kabir, learned counsel for the petitioner, reputed that the petitioner has not received the balance amount towards the GIS and Provident Fund till today. Considering above, Mr. PJ Fukon to bring on record the instruction, to bring on record the written instruction on the next date, and bring on record the written instruction showing the payment of showing the payment of entitlements, all the entitlements to the petition. List the matter after 3 weeks.
Obliged, my lord. Deeply obliged.
Item 9. 9.
Why?
People I have the same manner, whether these petitioners are
According to their similar situated person, my lord.
So she needs some time, that date may be fixed.
What you have submitted?
Thereafter, it is not being released
Hmm.
from the similar distributed process of council from school, the filing rate in manner.
Hmm.
Because the person who were filed by writ appeal, my lord, they are teacher, and here it is grade 4 only, and they are not yet till today terminated, so it is not fault, but she needs some time for regarding that.
See, last time Mr. Das has submitted that the BTC is yet to receive the supplementary demand for payment of salaries initiated in the year 2015.
Yes, my lord, they have also admitted to provide salaries, my lord. They have filed, you also know,
So who is not paying? Who has to pay?
director. They have filed, my lord, affidavit lawsuits, and
You
they
pay, you pay what's, or
Yes.
when you are admitting it,
There is dismissed, my lord, and we have come up for preparing the reports on. So that is pending, and that has been fixed on 77.
similarly situated teachers.
But I am not teachers, I am the, and we are not terminated. They have been terminated as a teacher. So we are still working, no termination is made. But we are also regularized as per policy decision, my lord.
But how
But
could,
they have also filed affidavit lawsuits, and they demand, they have stated that
how could you work for 20
for finance.
20 years without salary?
We have received money 2009. Someone is 2010 also.
Ah,
Initially, we received money.
15 years you have not.
After 15, my lord, 15 my lord, we have not.
10 years you have not received.
We have not received salaries.
How you survive?
Like they are still working, my lord. I don't know how they have survived, my lord, because I am also not taking anything. Pro bono service, my lord.
Pro bono.
What to do? They are not getting money, my lord. What they will do, my lord. That is why, and they have.
Are you sure? Pro bono?
Yes, yes, my lord. Sometimes I am doing like this.
Okay.
And
Third MSK Devi, learned council for the petitioner. MS D. Bora, learned standing council BTC, submits that similar matter which is dismissed by the coordinated bench of this court has been put to taken to an appeal which is pending before which is pending. Therefore, press for listing of the matter after 4 weeks,
to verify whether they are similar, the petitions
Yes,
are similar or not.
whether the petitioners, the case of the petitioner is similar to the case of those petitioners, which is the subject matter of the writ appeal. Mr. Prayer not being objected, the submissions not being objected, reputed by the by MSK David and the council for the petitioner. Let this matter be listed after 4 weeks, as prayed for by the London Standing Council.
Obliged.
This is for what?
Lordship may kindly peruse order dated 29/4/26.
Ah,
By that order, this court directed them to, Lordship will find relevant portion, para 9. Since 2015, they are hanging the matter, man.
Although there is a specific direction, the court has taken view that it will amount into contempt. And last two occasions also that took time back. Then that may be faced after vacation back. Because in the meantime, what I have, they will file it. Para 9 is very specific that, my lord.
Mister, you have not been reinstated.
As not reinstated.
So you have availed the remedy,
Yes, madam.
but then it was time barred. Second contempt petition was time barred.
Time back.
We are filing this writ petition.
Repeat.
For what? For what?
For allowing me to join, my lord. For joining.
That's already directed by this court.
Yes. So they should.
When you have,
They should implement the order, my lord. Because I've approached the authority.
when your
And they are not-
remedy is barred by limitation and it has been dismissed, how can you, is there liberty?
A liberty is granted, my lord.
Liberty for what? Filing a second writ petition.
Not filing the appropriate petition. There is no bar, my lord. I have a
They-
petition. I have a petition. Next date I saw your lordship.
So,
Next date I saw, my lord.
so now. You
Let
saw
them-
now.
Let them file, my lord. Let them file reply of this order, my lord.
What reply?
This order dated lordship 29/4/26.
Hmm?
Order dated 29/4/26.
No, I want to
State-
see when you are saying that there is no bar. When the remedy is barred by limitation
Yes, my lord.
and that the petition is dismissed. Since you are saying that there is no bar, you
That
saw
was
as this.
contempt. That was contempt, my lord.
Yes,
That was contempt.
yes. See, this court has granted you particular remedy, I mean relief.
Lordship.
That has not been complied with. You file a contempt petition,
Lordship.
then it was closed. Thereafter, you have filed a second contempt petition. It was dismissed on the ground of on limitation, on
Lordship.
being barred by limitation.
With the liberty to file appropriate petition.
What appropriate petition? What would be the
When-
appropriate
when-
petition?
Lordship, when there is a new cause of action, this is a new cause of action
What is the new
I-
cause of action?
regarding joining, my lord. Regarding my joining, my prayer is, lordship, find the writ petition, prayer of my writ petition.
First, you have to be reinstated. Then
Yes,
there's a
yes.
question. Then question.
I have already been reinstated, my lord.
Ah,
They did not allow me to join.
huh,
In this way, they are saying that BTC will allow me to join.
huh.
And this director of Assam is saying that we are not the authority. And now I am in hanging position.
Hmm.
So they should ascertain who will allow me to join. Let them file affidavit.
So you have been reinstated.
Yes, my lord. By this court, my lord.
Then why you have filed a contempt petition?
For complying of the order, my lord.
Then you said since you have been reinstated, it has been complied with.
No, but department has not taken any steps.
Ah,
Court has allowed me to reinstate. Court has set aside the termination order.
therefore, have you been reinstated?
Department has not been reinstated me.
Then it's a violation.
Yes, my lord. But this court has taken stand that they should comply. Because I have a decision whether today I am not having next date. Next date I will furnish your lordship. Supreme Court has said that it is the duty of the court to see whether order has been implemented or not.
Hmm.
Even if there is no contempt petition, second deed is also under 226, court has the power to direct to implement his order.
So us now. I have not come across, frankly. So
Today I
us
am not-
now.
Today I am not having my assignment.
We learn every day.
Yes, my lord, it is there, my lord. I've seen it. Yes, my lord, there is also one decision is there, my lord, and that is 2002 Supreme Court, my lord, Calcutta. There is also other decisions, I will satisfy lordship. Para 6, your lordship will find.
Calcutta High Court.
Yes, my lord. Para
Then
6.
you said Supreme Court.
FCC, my lord, AIR, my lord, FCC Calcutta. It is therefore certain law that the second writ petition is maintainable for implementation of the earlier order of the writ court. This court must issue proper directions for proper implementation of the previous directions. Where there has been an order that must be complied with an act done in willful disobedience of the court order is not only contempt, but also an illegal and invalid act. The language used in the Article 226 of the Constitution of India is couched in comprehensive physiology. And the said article recognizes a very wide power of the High Court to remedy justifies wherever it is found. So make it specific.
I am not persuaded. Where is the settled law?
There is
The
also
Calcutta High Court.
Supreme Court is also there. I'll find it the Supreme Court decision, my lord. Categorically, Supreme Court, I found that, my lord, today I am not having.
Huh?
Today I am not having that decision, my lord. Next week
I'm not persuaded by the observation in this
your lordship is not found, but
Honorable
ratio-
Calcutta High Court.
yes, madam. But Supreme Court is, I'll punish your lordship, Supreme Court.
Anyway, heard Mr.
Yes, not.
S. Not. S. Not.
Yes, not.
Then counsel for the petitioner. You want some time?
No, here, so there is an order passed by this honorable court, where this honorable court would make an observation that the director elementary education did not have the power to hold its power, the direction of this honorable court earlier past. And therefore, there is a contempt. We are filing an application, interlocutory application. For in fact, in the earlier round of litigation, where the termination order of the petitioner was set aside, it was basically relying on a judgment passed in several types of litigation, where the issue was that the petitioner being an employee appointed by the VTC, the state did not have the competence to issue a termination.
Have you filed appeal against those orders?
Malab,
Have
not
you filed?
necessarily, Malab, because that order was in respect of the competence of the state authority terminating the petitioner service. Now, Malab, the petitioner now has come up before this court saying that since the termination order has been interfered with, therefore he is entitled for joining. Now, Malab, the contention of the state was there is no record in respect of the appointment of the petitioner. And therefore, the termination order was issued, or not termination actually. It is an order directing the.
What is the direction of the court after the order of the court?
That order, Malab, cannot be complied with and cannot be implemented by the state.
Ah.
Since the petitioner is an employee under the PTA. And in fact, the order that was passed by the state was interfered only on that ground.
So you'll just, since the order is not capable of compliance,
So that
you'll sit over it.
that the petitioner.
You'll sit over it.
But I'm presenting the director elementary.
Who is BTC? Whoever is there.
Initial appointment may not be filed at page 26.
No, we're not going into that. What is the direction? What is the order passed earlier?
Direction lordship will find,
Unproven that being for this court in respect agreement so and so rendered in so and so according to impugn order passed by so and so.
Page 40.
Was consequent steps in favor of following the setting as indicated shall forthwith be taken by the respondent authority. Wrongly, rightly.
No, my lord,
Unless you have.
no, lordship will kindly see paragraph 3. The basis of interfering with the order is relying on the judgment of the in WBC 570.
That's why I'm saying wrongly or rightly,
I am
you
not
have to
saying-
file an appeal.
I'm not
If
saying
you-
wrong or right. Now this honorable court.
What you are trying to say is that the order passed, relied on by the learned single judge.
No, I'm not saying it's incorrect.
Then,
One of the order passed by this honorable court on 29/4/2026, my lord, kindly. Here, my lord, this honorable court at paragraph 5 has made an observation. Sorry, paragraph 9.
I have to file for with time the screen also. I have to file for. But I need to contemplate proper question.
yes,
The same fellow that in view of this, fellow, we are finding an application for recall of this order. Now the core issue which has to be decided in this situation, in pursuance to the order passed by this honorable court setting aside the termination, who would be the authority who would enable the joining of the petitioner? Since the petitioner is not a employee under the Director of Elementary Education, whether the Director of Elementary Education would be empowered to give him a joint.
Then how can he dismiss?
Because my dismissal order was interfered solely on the ground that
Okay.
since he is not my employee.
it is you to sort out. Either BTC or the director, we don't know.
That's what the dispute, I think, my lord.
You have already, who has dismissed the petitioner?
We dismissed it.
Then,
That was interfered, saying that we do not have the competence.
therefore,
Since we do not have the competence, the petitioner not.
see, you cannot re-argue this matter.
No, I am
This
not-
is a question of whether you have complied with the order or not. Basically, writ petition is for implementation of the order.
Yes. Now, who would implement? That would be the issue.
You decide, who will say that, will not decide.
Whether the state.
See,
has-
this, Mr. Kaushik, is a very strange argument. You have not filed a appeal, you have not filed any review,
We have filed our.
you have
affidavit.
nothing, anything.
We have affidavit taking a stand
Hmm.
that since the petitioner was appointed by the BTC authorities, since the petitioner was BTC authorities and our subsequent termination was held to be bad for having no jurisdiction, therefore, we cannot give him a joining. That's what my stand.
Let them file I, my lord. File I.
I think we'll throw a sumoto.
No, my lord,
You have read it, 9 and 10.
if your lordship will kindly see, this is the earlier order.
We're not going to, we're not going for rehearing. We're not going for rehearing.
That's the important. Why?
No, it's not important. It's no relevance. Wrongly or rightly, the court has passed the order. You have not filed any appeal or review against the order. If you think that this is incorrect,
My lord, if your lordship kindly appreciate for a moment. If lordship kindly come to the earlier order at page 42, paragraph 3. For the basic.
we're not interested. No. You cannot, we cannot rehearing what has been already decided. Unless this is an appeal and review. Who is stopping you from filing appeal or review?
10 years has gone.
The way you are projecting the case is a case of either the appeal or review.
My lord, if your lordship kindly bear me for the moment of page 42, paragraph 3, my lord.
No, we are not interested.
Yeah.
Either we'll draw this, as per this order, we'll draw sumoto.
This time to file my interview. But I have already sent it for vetting.
Yeah, the time is in argument for the premier there.
You could have insisted. Judicial order has been passed.
Yes, my.
Then heard Mr. Esnath, learned counsel for the petitioner. Although this court having considered the entire matter on 29/04/2026, has observed that there is a deliberate and willful violation of the direction passed by this court. Please stop accordingly. The suo motu contempt proceeding is required to be initiated against the Director of Elementary Education, Assam. However, the state respondents were provided an opportunity. No, the Director of Elementary Education, Assam, was provided an opportunity to take remedial measures before the next date. Else this court would proceed with proceed to draw a suo motu contempt against the said against the Director of Elementary Education, Mr. B. Kaushik, Learned Standing Council, Elementary Education Department, pressed for 2 days' time to file appropriate application, bringing on record the measures initiated by the Director of Elementary Education. Please, ordinarily, the court would have proceeded to draw suo motu contempt proceedings in the facts and circumstances as present case, facts and circumstances of the case, is fit for 2 days' time is granted to Mr. B. Kaushik, Learned Standing Council, to bring on record the remedial measures as observed by this court. Remedial measures that has been taken note of. No, the measure is taken by the Director of Elementary Education, which has been taken note of by this court on 29/04/2026. List the matter after a week.
Last date may be fixed, my lord. Date.
Next week. Give any day. But Mr. Kaushik, be careful. Already is there. Only you have to take the remedial measures, nothing else. You cannot change it unless you file a review or not at this stage. It has to be filed independently.
That's
Because of the observation made is 29/4. Rather, I am deviating, which would not have been taking a lenient view. Rather, I am debating. I am not. It appears not following the judicial discipline.
Take my application by PROCEEDINGS.
Your application has I have recorded remedial measures. Else, will proceed. Not anything. Not anything else. Only remedial measures.
I'll try to satisfy you.
You will go through this 29/4. It's very clear.
I'm plus the 29/4 made certain observations.
You have shown me.
Yes.
You have shown. I refuse to see. But then you insist me to see.
That's the reason.
You have, अपना पैर में कुल्हाड़ी मार दिया.
Obliged.
Be careful.
I'll try to pursue your lordship.
I refuse to see that order, although I know.
I'll try to pursue. Item 11.
May I please, your lordship?
Yes.
This is the case for arrear salary of the petitioner, my lord.
Why you have not settled before the mediation?
We have 3 to 4 sittings, my lord,
Ha.
but the department has not agreed with us.
Why you have not been paid?
My lord, this up to the department.
What is their stand?
In their affidavit, my lord, they have stated that the claim is barred by limitation for 3 years, my lord. And I have accordingly also filed the reply, my lord. So it will be admitted for hearing, my lord. Admitted for hearing, my lord, since hearings are complete, my lord. And after vacation, your lordship may take up the matter.
If your claim is barred by limitation,
No, my lord.
how you are entitled?
No, my lord, because my lord, I have been reinstated in the service in the year 2022, my lord. And I have filed the writ petition on 10/1/2024, my lord. So the limitation is for 3 years, my lord.
Not Mr.
I alone.
I Alam counsel for the petitioner. And also had Mr. SMTC State Learned Standing Council, Secondary Education. Admit list for hearing after in the usual course.
My lord, after vacation, that is.
Usual course. Anyway, after 4 weeks. 4 weeks.
Obliged, my lord.
Well. Back to the.
My lord, in this matter, my lord, there is a development, my lord.
What development?
My lord, one representation submitted, my lord, in the additional affidavit. I have submitted this representation because, my lord, some similarly situated, my lord, person have been given, my lord, benefit, my lord.
Who?
Director, my lord. And I have annexed this in my additional affidavit, my lord, this order. And this my consequential representation submitted, my lord. Lordship, kindly have a look. Here, background of this case, my lord, kindly I may be allowed to state before your lordship.
Will disposal? We'll go for disposal.
Yes, my lord, only my lord, may be disposed of, my lord. Petitioners before your lordship are, my lord, drop teacher. In Assam, my lord, it is called drop teacher because, my lord, one private school was opened, my lord, then subsequently teachers were, my lord, taken as a government employee. But due to insufficient post, my lord, some teachers like present petitioners were dropped, my lord, not provincialized, my lord, made government teacher. Subsequently, my lord, this honorable court passed one judgment. Lordship, kindly have a look. I have annexed for ready reference. This is the, my lord, page, my lord, 15 is the judgment, my lord. And in this judgment, this honorable court was pleased to direct that, my lord, our service should be, my lord, provincialized and with prospective effect. But, my lord, we should be given benefit of the pension from the original date when, my lord, school was provincialized. And this, my lord, relevant paragraph, my lord, page 18, Roman 6, my lord. Accordingly, my lord, we have regularized, my lord. All the appointments made would be prospective, but will carry the benefit of past service for the purpose of competition of pensionary benefit, my lord. Thereafter, lordship, we filed one writ petition, and pursuant to this writ petition, my lord, we are regularized, my lord. Our writ petition, my lord, I beg to show this order, my lord. Page, my lord.
What is your prayer here?
There, my lord, lordship, kindly will look. We are given everything, but our, my lord, regularization order, my lord, page 34. And we are, as per the direction of this honorable court, we are giving old pension benefit also, my lord, 1969, my lord. But here, my lord, our date is not clarified, my lord. In the, my lord, page 42 order, whereby we are taken into, my lord.
Grant the incremental benefits to the current salary of citizen when their school should for when their fellow to
Page 42, my lord.
42.
42, my lord.
Hmm.
Here, my lord, by this order, my lord, we are taken into, my lord, under the old pension rule, 1969, my lord.
Hmm.
Our DPF account, everything is given, but date of lordship, right hand side, my lord.
Affidavit has been filed. They have filed the affidavit.
No, my lord, we have filed one additional affidavit. my
So
lord.
they have filed the affidavit or not?
No, my lord.
Then you are unnecessarily arguing the matter.
This representation,
Heard, mister?
my lord, this representation.
Heard,
is
mister?
considered, my lord.
Huh?
Only this.
Huh? You are claiming? I mean, it's not simple as that.
I may be allowed to, my lord, submit a representation that much only, my lord.
Huh?
Now, my lord, as director are, my lord, giving benefit, similar benefit to similar tier, so we may be allowed to submit representation only, my lord. Let director, lordship, just similar order, lordship kindly have a look, my lord, you will also see. Similar order passed, my lord, page 56, my lord, 55, my lord. So we may be allowed to submit representation and let director, my lord, consider at first, my lord. And to that effect, my lord, we have already submitted our representation, my lord.
That has been already rejected. Similarly situated.
No, my lord, page 55, my lord.
See, as per their instruction, they similarly situated persons, they have in respect of Nagaon district,
My lord.
has filed a representation and that authorities has already rejected their representation. The same fate will be there.
Lordship, just kindly.
So
my
will
lord,
not issue in-notice orders.
Kindly, my lord, page 55, my lord. Page 55, my lord.
See, it's their instruction. Suppose there's no difficulty for this court to allow you to file a representation and consider.
Yes.
Similar fate will be there
But,
because their stand is very clear.
But this order.
See, I'll just say similarly situated teachers under the Nagaon district had earlier submitted before the government seeking similar. However, the government rejected the claims by stating this are entitled to serve with effect from 2005.
Yeah, but this order is very recent, my lord, page 55, my lord.
Huh?
Page 55 before your lordship.
By whom?
By the director, my lord.
Hmm.
Lordship, kindly have a look.
Which is that order?
Page 51 NHR AI.
Which date of order?
Date of order, my lord, this is 2024, my lord. One first.
This is 2026, 2026. May 2026. Their stand is.
Therefore, my lord,
What I am trying to say is there is no difficulty allowing you to file a representation and direct them to consider and dispose of. That will be a futile direction because their stand is very clear that the government has already rejected the similarly situated application. What I am trying to impress on you is
Yes, sir.
for your benefits.
Yes, sir.
So should I say that? Will allow you to file a representation, consider and dispose of.
Yes,
That's
sir.
all.
Yes.
Again, you will come back. Heard, mister?
A.M. Borbuya.
Huh?
A.M. Borbuya.
A.M. Burbuya, learned counsel for the petitioners. Although the petitioner, no, will not say. Mr. M.S. M. Pukan, N. Pukan, learned standing counsel, elementary education, submits that she has received the instruction which she would like to bring on record by an affidavit.
2024, madam.
By an affidavit, therefore prays for listing of the matter after 3 weeks. Prayer is allowed, list the matter after 3 weeks. In the meantime, the standing counsel to file the affidavit
date
of
may-
opposition.
Any date after that.
Increment, you are still serving.
Yes. 2024, madam.
Huh?
2024 only, yet not filed. madam. They will file then, my lord. 2024, madam.
Yes,
Keep
next.
look.
You send, you give it back, huh? Return it.
That will look.
Yes.
The petitioner is a widow of late Atul Chandra Sharma. He retired from the Gauhati University,
Hmm.
assistant registrar.
Hmm.
So he expired on 31/2022.
Hmm.
Till his date of death, he was getting pension.
Hmm.
But then when he expired,
Hmm.
I submitted death certificate and completed all the formalities, but the family pension has been not given to me. Folks.
Ah.
This is my case. Okay. University.
Yes, What is your stand? Hmm. Page 21.
So all the necessary steps they are putting in the pipes. Your concern usually should be giving the subject, but partly from us, that I am not entitled to get a of other date so and so, do my date, but then we are it. So and so does not take any step to write a letter to us, the same subject. And we promise to partly by my representation. Say so and so, we need so and so. He makes it clear that there is not a different outcome. We have a case I therefore request to find the text for any and further director going to provide a copy of the rules of what this is and my husband.
Yes. Then
Kilometer. One person, till one person. You know, the petitioner should be entirely dependent upon the upon her husband. And further, the nomination aspect is also there. So whether it is in conformity with the rule 137 or 137, what's after not known that yet. And further, there's full university where he served, after 97. That university has not been made part. Technically, the full university has been treated as part of Pardon,
no, once a person claims for family pension,
Yes.
is it not a duty of the authority whether she is or he is entitled under the rules? Unless you ask them, I mean the required documents or whatever, including any information, how the person who is claiming entitlement would I mean know? Hmm.
Whether she's actually the nominee of her husband, whether she.
We don't know. It is your duty. Suppose if somebody claims, you have to look into the rule, and if requirements is there to show, you have to ask them that to produce documents or show them that you are entitled or you are the thing as per the rules. Unless you do that, how the claimant would, I mean, the person who is entitled would know. Hmm. We don't know. What do you say?
They have filed affidavit, all these grounds are not taken in their affidavit. Affidavit filed the university on the record.
What did they say?
Lordship, nothing, Lordship, they just putting the post.
Huh?
Nothing has been clearly stated. They said that balance of convenience in favor of the university, so she is not entitled to pension. Nothing has been stated, what has been submitted by my land.
Then in that case, you are also not clear. So the petitioner is their wife.
Petitioner wife and my husband was getting till his date. He expired on 31/2022. Till that, Lordship, my husband was getting pension. Thereafter, after death of my husband, I submitted all the documents, including the death certificate. But Lordship, they stopped payment, giving payment.
So in that case, we'll direct you to file a fresh application before the authority.
Lordship,
They will consider within 1 month
Lordship,
on receipt of.
that will do.
That would be better because
Lordship.
it's not clear. I mean, except the fact of undisputed fact of you being
Lordship,
the.
I submitted 3 representation from 19/4/2022, just after death of my husband. Lordship. Nothing has been given, no order has been passed on this application.
So you file a fresh representation now,
Lordship, that will, I'll do.
since you have,
Yeah.
waited for so many years.
Lordship.
Or Mr. S.C.K. Learned Counsel for the, Learned Senior Counsel assisted by M.S. R. Ushan, Learned Counsel for the petitioner. Next paragraph. The petitioner has instituted this writ application seeking a direction to the respondent authorities to pay family pension to her in respect of the in respect of late husband who had expired on
31/2022.
30/01/2022. List of next paragraph. And also had, sorry, they also had Mr. P.J. Fukun, Learned Standing Counsel, Gauhati University. For all the respondents. Next paragraph. The late husband of the petitioner was working as in what capacity?
Assistant Registered Administration.
Assistant registered in the Gauhati University. Was an employee of the Gauhati University who has served in different capacities and finally as an assistant registrar
Lordship.
and retired on 31/03/1997
31, yes.
on attaining the age of superannuation. List of the after the retirement of the late husband of the petitioner, he was receiving the what pension
Lordship pension.
till 29
31/2022. Till his date of death.
till the date of his
Death.
death. This stuff. Till the date of his demise, till the date of his demise, 13/01/2022. Mr. Following her husband's demise, the petitioner approached the respondent Gauhati University for grant of family pension in place of her late husband. Mr. The petitioners submitted several representations before the respondent authorities. List of next paragraph. It is the contention of the senior counsel for the petitioner that the petitioner is the wife of late. That contention of the learned senior counsel for the petitioner that it is undisputed that the petitioner is the wife of late Atul Chandra Sharma, who was the employee of the Gauhati University. And after his retirement, he was paid regular pension till the date of his demise on 13/01/2022. List of the petitioner being the legally being the wife and the legal heir of the late Atul Chandra Sharma is entitled to be grant with the family pension on the date of her husband. And therefore the denial of the family pension is arbitrary and illegal. Mr. Next parent, Mr. P.J. Pukul, Senior London Standing Counsel, submits that as per the applicable rules, the person who claims family pension has to establish that he or she is the legal heir of the deceased employee, who is totally dependent on the said on the deceased husband, the deceased employee. The aspect of the nominees in the service book is also required to be established. However, he fairly submits that since the applications of the petitioner for payment of for grant of family pension in respect of the late Atul Chandra Sharma appears to be not considered and disposed of. Appropriate order may be passed. Appropriate direction will be passed to consider and dispose of the representation filed by the petitioner. That is what you are saying.
Those from one person.
It's okay, applicable rules we say, because we are not deciding on the merit, right? Next paragraph. Having considered, no, please, upon consideration of the land council, submissions of land council by the parties, and also having considered the materials placed on record, it appears that the petitioner is the legally wedded wife of late Atul Chandra Sharma, who was an employee of the Gauhati University. On the retirement, after the retirement of the late Atul Chandra Sharma, he was paid the regular pension till his demise on 31/01/2022. 30/01/2022. The petitioner appears to have submitted, approached the Gauhati University on several occasions for grant of family pension in accordance with the, in terms of the applicable rules, as she is the legally wedded wife of late, legally wedded wife and a legal heir of late Atul Chandra Sharma. However, the authorities appears to have not considered the same. Next bill, having considered above, and also is agreed to by learned counsel for the petitioner parties, I deem it appropriate I am of the considered view that the authorities are required to consider the grievance of the petitioner for payment of, for grant of family pension in respect of late Atul Chandra Sharma, who was an employee of the Gauhati University, to the petitioner in accordance with the applicable rules. This stuff does, since it is, since the petitioner who is, as the petitioner who is the legally wedded wife, who is the wife and legal heir of the late Atul Chandra Sharma, so and so, Atul Chandra Sharma would be entitled for family pension on the date of the disease has, the date of her disease has spent. Next para. Non-consideration of the grievance by the respondent authorities would amount to an arbitrary act on the part of respondent authorities, particularly when the petitioner is entitled to family pension under the applicable rules. This stuff. Next minute. In view of above, I am of the considered view that interest of justice would serve if this writ petition is disposed of with a direction to the respondent authorities to consider the case of the grievance of the petitioner. Grievance of the petitioner. Accordingly, the petitioner is directed to file a first representation with all the relevant documents, and on receipt of such first applications. No, within a period of 15 days.
Yes.
15 days from today. List of on receipt of the application of the petitioner. On receipt of the application, the respondent authorities, particularly, will consider register Gauhati University, shall consider and dispose of the representation by granting family pension in accordance with the applicable rules. The exercise directed to carry to the directed to the exercise directed to be carried out shall be completed not later than within outer limit of 1 month from the date of receipt of the application. Rate petitions accordingly stands disposed of.
Wait, initially, my lord, the petitioner was appointed as an LDA. My appointment letter is, my lord, at page 28, my lord. Page 28. Subject to discharge without notice and without assigning reason, my lord. Therefore, thereof, say Subodh Kolita, selected by selection, was hereby appointed as an LDA, my lord. Thereafter, my lord, I was upgraded to the post of assistant teacher. And my services were confirmed on 28/9/2012, my lord. Kindly come to, my lord, page 54, my lord. Page 54. 56, 55 is the original.
Dismissal.
Dismissal, my lord.
Will hear.
Rule 9, my lord.
Will hear. Admit and we'll hear.
Otherwise, my lord, or your lordship can have it after the vacation, my lord,
Ah,
because it's a small
we'll,
issue.
we'll admit it.
Admission, my lord, it will go for hearing.
Yes.
After vacation, my
Today
lord,
we have the hearing list. It's a particular days are fixed for hearing.
my lord can
I
fix
mean
it.
Thursday, the Tuesday and Thursday we're taking a hearing.
Any hearing day, my lord can fix it. My lord.
Huh?
After vacation, any hearing day.
We'll admit it and hear it.
Admission.
List for hearing.
Because issue is, I'm just.
Heard, mister?
Hearing.
Heard, mister?
AK Borua, my lord.
A.K. Barua, you have been dismissed.
Dismissed and my lord, without any.
A.K. Barua, learned
stipulation.
counsel for the petitioner and also had MS D. Musari, learned counsel, learned standing counsel, secondary education department correspondence. Admit list for hearing. After 4 weeks on
My lord,
hearing day, you just give the hearing day.
Can it be on,
Either Tuesday or Thursday,
can it be on 23rd, my lord?
23rd.
23rd July.
It's okay. It's okay. 23rd.
Alright.
7.
In 16th.
Wait, lordship, my lord.
Yes.
The lordship here. This case is covered by a number of decisions of the school, my lord. Coordinated branches. One leading question 7-2-1. Following the my lord, decision in 7224 of 2018. Number of cases are disposed of. Here what my case. My case was recommended by time and again by the PTC Council, my lord. The district level constitutional committee. Yeah. Far back in 2017. Then again, director asked for fresh proposal. That was submitted through BTC secretary, education secretary. But till today, my lord, it has not been considered and he was not formalized. His service were not formalized.
Seeking provincialization.
Yes.
Yes, madam.
And
Ready?
the government has filed everything, my lord.
You're ready? We'll hear the better. If you are ready, we'll hear the learned senior counsel.
They were admitted in the evidence also, my lord.
You have admitted that they are entitled.
But their own admission in the evidence, my lord. Paragraph 9 of the evidence, my lord, page 68.
Since when you are not been working? Still you are working.
Yes, still I am working.
Your name has been, the proposal has already been sent.
Twice, thrice.
By the BTC?
BTC.
Yes, who is why the government is not considering? So then who has to consider? State.
The government. Director of
Who? This will go to the state, state selection committee, state level committee.
my lord,
Is it required, not required?
I think my lord, if you are lost, my
What is the procedure? Once the recommendation is from the concerned authority, in this case, BTC. You have recommended, then who has to consider, sir?
BTC under the 6th schedule, my lord, 2003 6th schedule amendment has been brought so far as board and council is concerned. The BTC is the primary authority to for primary education, secondary education, even college level, general. My lord.
No. Once do you agree
Only
that
they have to
this
approve it.
proposal has
No,
been,
only that
they have recommended?
Yeah.
Do you agree that they have recommended?
Yes.
They can recommend. Then now who has to consider?
Consider and the approval is required from the director.
Director, who is for director? Yes. Then what is your stand?
9.
You tell us first. We don't go referring to the paragraph. You just tell us what is your stand on briefly. Or madam, if you are not ready, we'll list it for some other day. We'll hear it, and if you are admitting, we'll just
Admitted.
we'll direct you to approve it. What is your stand? Let us see. Have you your authority has taken any action or any rejected or approved or whatever?
No, they have simply said we have considered similar cases. Consider.
You'll consider. You'll consider. You'll consider. Let us see when the affidavit.
Relevant.
Respondent director, yes, where it is, para 9.
9, page 68 and 70.
I think probably was elected with the position and the problems both investments. Underqualified.
No, they are qualified.
Although an office member and probably office to only proposal relating to Vision was only on 2007 subsequent to the invalidation of and therefore could not be processed under the said repeal. Therefore could not be processed under the said repeal. It is however some several cases considered.
And page 69. Orders, we place the order.
Otherwise, you are not saying anything. There, your only ground is that the case of the petitioner was forwarded after the invalidation of the Act of 2011. However, you have considered the similar situated teachers.
Yes.
What is similar situated teachers?
I have given the order. However, submitted that certain cases of similarly situated teachers were considered under this 2017 Act strictly in compliance with the exclusive direction issued by the Honorable Court. They are depending on this court. They do not take action on their own.
Just to give.
You read what we have? Double PC number 6804 2017.
Yes, in view of your this stand, will dispose of in short order. You consider as per the this thing.
Similar order before.
You consider as per the recommendation and taking into account the similarly situated persons which you have already considered.
Yes.
You will direct it within 1 month.
Yes.
1 month. 1 month from today. 2 months. Okay. Director. Okay. Dispose of. Short order. 2-page order would be there.
But my lord, Lordship Makari side the other decisions I have given.
Huh?
The decision.
Well, 2-page order, since they are not admitting and the BTC has already forwarded.
British
May
judges,
no-
my lord, British judges used to write.
I think it may be, I mean, less than 2 pages.
Yes, effective
come.
order is even 1 line is.
Heard, Mr. RP Sharma, Learned Senior Counsel, assisted by
Deed of the.
Learned Counsel for the petitioners.
Yes,
Petitioners.
yes.
And also have, you are one. MS, ESCO, Learned Standing Counsel for Elementary Education Department. Elementary. Elementary Education Department for respondent 1 and 2, as well as MS P. Bora, B, Bombay. Standing Council BTC for respondent number 3, 4, and 5. That's all. Dispose of within 2 months, right? 2 months. Well, 21. What is the matter about?
Excess, recovery of excess amount.
Excess
Excess amount.
recovery of.
Excess development.
Okay. They've deposited. You are working as?
Now I'm retired, madam, working.
No, where? Huh?
Assistant teacher, madam.
Assistant teacher.
Yes, madam.
Then
Then, madam, upgraded to gadget teacher, madam. Retired from, madam, 31/10/23, madam. Paragraph 5 and 6, madam, still okay.
see, for fixation of this your thing, basic pay, you have given a consent, and accordingly that has been fixed. Therefore, once you have given the consent for fixation of your basic pay, right? And they found that there is actual drawal of 2 lakh something, then what remains, Mr. Saikia? Huh?
Some amount was recovered after his retirement.
Doesn't matter. You have given a consent. The excess payment is in respect of your basic pay was fixed, which you have given a consent. So accordingly, you have deposited also.
My lord, that cannot be, that is not
That is permissible. Once you have given the consent, it's not that they arbitrarily they have sought to recover after your after your retirement. It's not arbitrary. See, once you have, suppose you are entitled for your basic pay is 10 rupees.
My lord.
You have drawn 15 rupees, and for refixation while preparation of your pension, you have given a consent for
Also,
refixation. I
because,
mean, to give the proper, basic pay, which you have given your consent.
But the now level score.
Once you have given the consent, matter ends there, disposed, writ petition dismissed.
I was possibly not dismiss this petition, my lord, because my lord,
the recovery part, they cannot do the after
We'll
retirement.
distinguish the wrapping machine or the thereafter cases. What's
Thereafter,
there?
even this honorable court also.
So we'll
said that,
distinguish it.
Even in cases
We'll
of,
distinguish it.
in cases of,
Writ petition dismissed.
in cases where recovery was made, this honorable court directed the authority to return back the recovered
No,
amount.
that may be facts, depends on facts and circumstances, effects of each case. Because here is a case you have given a consent for refixation.
Consent cannot confer any right on the government to.
Why
do
not?
illegal
When it is found that you have been allowed to withdraw inadvertently or rightly or wrongly to draw the amount which you are not entitled or above the beyond your entitlement,
Even the last.
then you have been sought for you have given the consent.
Last pay drawn was given by the head of the institute, my lord.
It's all right.
But
That understood. It may not be your fault at all. But problem is, you were fair enough to give the consent for proper fixation. And accordingly, on the basis of that, your consent,
that
it
amount,
was fixed according to your entitlement.
Retired
Then-
person, retired teacher, my lord, that amount recovered, my lord, that may be returned back to him, my lord.
How?
Because,
How?
my lord, it was. It is
No,
not
once you have
permissible.
accepted the basic pay, that you are entitled this much.
I have
And
not
if there is
accepted that.
excess,
I
you
have
have
not
to
accepted
fairly,
that, my lord.
deposit, it's a public money.
I preferred it, and my lord, I.
It's not
preferred an
somebody,
application.
it's not a kind of business transaction.
My parent department, my lord, education department, send a proposal, my lord, for refixation on the basis of my application, my lord.
Yes.
But the pension department, my lord, they have rejected my claim.
Ah.
That is under challenge before this honorable court, my lord. I have
Because you
accepted
have
that.
already
It is
given
not
a
that I have
consent.
accepted.
You have already given a consent.
Because my pension was not being fixed and that is
Anyway,
why
it's of
the
no
amount
use
was
in
re-
that case.
returned
What do you
back.
want?
My lord.
That's all.
Proceed may kindly, my lord, direct the authority to return back the recovered
No,
amount, my
no,
lord.
that cannot. Once it is fixed, your entitlement, then if you are found to have excess drawal, how can we direct them to return?
Proceed may kindly peruse, my lord, these two judgments, this honorable court held that, my lord, even if recovery is made, my lord, that is required to be returned back to the retired person, my lord.
Huh?
Even if recovery is made after the retirement, my lord.
It
that is to be-
depends on facts to facts. Have you not given the consent?
It was, consent was given on the, my lord, basis of some pressure created by the authority that his
Come on,
pension was not.
please don't make unnecessary submissions.
This was submission, my lord, Lordship may record these judgments also, my lord. Lordship may.
And Mr. IS learned counsel for the petitioner. No, I'm not disposing of. He's not happy. We'll grant you, we'll provide an opportunity. As prayed for by Mr. MS K. Pukon, learned counsel, standing counsel, as learned state counsel. Let this matter be listed after 3 weeks. No, you just write. MS K. Pukon, learned state counsel, submits that she has received an instruction to which she would like to bring on record by an affidavit. Therefore, praise for listing of the matter after 4 weeks, 3 weeks, huh? Next para. Praise the Lord, list the matter after 3 weeks. For filing affidavit in opposition by the state council. Next para. After hearing the learned counsel for the petitioners, it is seen that the petitioners, both
Both, my lord.
petitioners have already given a consent for refixation of his basic pay, which the petitioner has already, for which the petitioner has refixed, to which the, accordingly the respondent authorities have refixed the actual basic pay entitled to the petitioner. On such refixation, the excess amount of rupees, it's here, huh? Rupees 2 lakhs 32,000
One case, my lord, 2,32,651. That
Both,
only-
in both the cases, you have given consent.
In both the cases, my lord, it is their case that.
Why, what I said last.
Pay fixation, excess amount of rupees 2 lakhs.
32,651 in respect of the petitioner in WPC 3354 of 2025 and rupees
2,76,049 rupees in respect
two
of
se- 2,76,049
49.
rupees 449
No, my lord, only 49.
04
Fine.
49 rupees are sought to are found to be excess drawal and sought to be recovered. List of to which this court prima facie found that found that the excess drawal sought to be recovered appears to be reasonable, as the petitioners have given the consent for repatriation of their basic pay. List of given consent for refixation of their basic their entitlement of basic pay without demur. DEMUR, huh? No, without demur, rather consent, rather consenting such refixation. It's okay. It makes sense. It makes sense. However, on the prayer of Mr. I. Serkia, further opportunity is granted to address this court as regards the propositions of law with respect to present issue, coupled with the prayer for respondents, state respondents to file their respective affidavit. B. Sharma, Learned Standing Counsel, Accountant General, and Mr. Who else? H. Alia, Learned Standing Counsel, Finance Department, as well as so and so, are present. State Council, Standing on Secondary Education. Your name is already, you are on top. You are number one. List the matters after 3 weeks. I just counting your time.
My lord.
Yes, yes.
Without the consent.
Yes, yes. We'll add that and accordingly voluntarily deposited. That will be with adding. It's of course the prime facie.
23.
Yes. Today. Yes.
Today I have got this copy. Lordship, on the last occasion, record was also called for. Lordship,
Dismissal.
compulsory retirement.
Compulsory.
Then we have to produce a record.
Okay.
That is not the order.
Since we have already filed our affidavit, Your Lordship.
Record in this case, Lordship, will require. That is why this honorable court, Lordship, considered that there is no alternative.
Heard Mr. M. Khan. M. Khan,
Lordship.
Learned Counsel for the petitioner. Next para, it is submitted by MS P. Das, Learned Standing. What I said? See, did I say Y, X? P? It's not P.
Yes, sir.
P. Das, Learned Standing Counsel. Elementary.
Second.
secondary education, that an affidavit has already has been filed today. We're furnishing the copy of the same to the learned counsel for the petitioner, to which Mr. Khan, learned counsel, has accepted, huh, Mr. So,
Can it be 21st of
has agreed to
July?
the learned counsel for the parties. Let this matter be listed after 3 weeks
Date
on
was
21st,
21st of July.
21st July. 21st July.
July. God bless.
On the next date, MSP Das, learned counsel, Ms. MS Das, learned standing counsel, produced the record. It's a compulsory return, we'll see. Record, huh? And you are wrong. Last order, apart from filing an affidavit, you are directed to produce the record. Why? It's up to you. Records, we would like to see the record. And
24.
yes,
I put up private respondent. I had 10. Sometimes it requires file.
what about the last order? No, what is the status? Whether you have inquired into? Then you have inquired into the matter, which is very, huh? Tell us. Who are you? Who has issued the certificate? Deputy District Commissioner. District Commissioner. Who has issued the caste certificate?
Deputy Commissioner.
Obviously, District Commissioner. Who are you? Who is respondent number 9?
Special committee. We have verified.
You are respondent number 9, Caste Scrutiny Committee. Huh?
No, they are private respondent, my lord. They filed a complaint, my lord.
You are not concerned.
No, my lord.
At present, you are not concerned. We are not concerned about you. You are the complainant.
Yes, my lord.
On your complaint only, this has been
Due to their complaint, my lord, matter was still not filed.
Janajati Satya Semmilan, Assam Moody Samaj Central Committee. You are the complainant. You are not the authority to inquire into and decide. See, there was a direction on the last when this notice was issued. Some direction was given. Is to be verified by authority issuing such authority. Who is issuing authority? Deputy Commissioner. Huh? I just wanted to know, sir. As per the order of this court, have you verified who is respondent number 3? Nay, Deputy Commissioner has to first verify. And then if it is doubtful, it has to be placed before the Caste Scrutiny Committee. What is the status now? Have you verified, Deputy Commissioner? So you are violating the court's order. Yes, madam, what is your? Hmm. 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 Tell us whether there is any verification or not. Hmm. Okay. So you have verified, then you are providing an opportunity to the petitioners, right? That is before the Deputy Commissioner.
Complaining for the number 10. And my lord, respondent number 9 is the special committee decided by the respondent number 9.
Hmm.
There is a verification.
Hmm.
Verification conducted by my lord the respondent number 9 member. And the respondent number 9 was requested the agency to my lord verify as particular mother party. I will find my lord.
Okay, heard Mr. So learn counsel for the petitioner.
My lord, in this regard, my lord, the similar case
Learn counsel for the petitioner. As brought forward by the learned counsel for the respondents, further 3 weeks' time is granted to file their respective affidavits.
May I make a request, my party to this matter, my lord. Some analogous matter is pending before this council.
List this matter along with.
One.
Give the date.
Find the number.
My lord, lordship, Prohibition 1685.
1685 of
2026, my lord.
2026.
Another 1686 2026, my lord.
1686.
1686 2026, my lord. Another.
Both.
When both. And there
1692.
1692 another matter, my lord. 2026, 1693 2026 another matter.
4 matters.
4 matter.
You give the list, just give it. Take it. 4 matters.
4 matters.
List along with this, list the matters along with WPC, so and so, so and so. 4 matters. And last one you says M, WPC, so and so.
25.
Yeah, please.
Yes.
We are tutor, my lord, working in various LP and ME schools, my lord. We entitled for equal pay for equal work, my lord.
Affidavit. Heard, Mr.
HL Ashko, my lord.
SB.
HL Ashko.
HL Ashko, learned counsel for the petitioner. On the prayer of Mr. G. Pego, learned standing counsel. Elementary is further 3 weeks' time is granted to file affidavit in opposition. But this is, you are serving,
Yes,
tutor,
yes, ma'am. Serving.
great pay, no urgency.
Most.
26.
May I please, your lordship?
Yes.
Here, my lord, my promotion to the post of headmaster has been withheld, my lord.
Ah.
My initial appointment as a science graduate teacher in the year 1993, my lord. Thereafter, on 2005, my service has been regularized, my lord. And in the March 2026, I have given in charge, my lord. as a headmaster in charge of this said school, my lord. In the month of my lord, May, my promotion list which has been sent for the to the post of headmaster, that has been withheld on the ground that, my lord, while my service was regularized, my lord, that was given with immediate effect. Although my similarly situated person has been given from the date of joining, my lord. That is my case, my lord.
Where's the order?
My lord, order is
Impugn order.
impugn order at page 38, my lord.
Hmm.
My name is at serial number 13.
Saying what? 38?
38. My serial number is 13.
In respect of the interpretation, I am to inform you that the hearing date is fixed as mentioned below at the office of the director of assembly regarding selection of regular master provision. Yes, secretary which are kept on hold are enclosed. You are to inform the candidates to present in hearing and so on. Yes, it is for hearing.
No,
How
my
can
lord,
you settle it?
apart from that, my lord, page 28 kindly peruse, my
No, this is you are claiming that you should be given a regular headmaster, principal. What is this?
regular headmaster.
Headmaster.
Yes, my lord.
So your case was withheld
Withheld, my lord.
while you were working.
Working, my lord.
As what? You are regularly working.
In charge, my lord.
In charge. Then for consideration, your in charge has been withheld, and you'll be heard.
My lord,
What's wrong here?
apart from that, my lord, page 28 kindly peruse,
What does it say?
where my regulation order, my lord.
Forget about this regular. What is this? Have you been appointed? What regulation? Ad hoc appointment, Sri Johnson, assistant teacher, Sangat, met where so and so. Have regularized in post. Other post. What is your post?
Well, as a assistant
Yes.
science graduate teacher, my lord.
Huh?
As a science graduate teacher, assistant teacher.
Then?
Then, my lord, thereafter I have given the in charge headmaster, my lord.
So?
While sending for the promotion to the post of
What is the in charge headmaster? This is for regular.
regular, my lord.
You will be heard.
My lord,
You have been allowed to all in charge, and it has been withheld, and you will be heard for the consideration for regular headmaster.
my lord,
How can you challenge it? You don't want that, you should not be heard. In fact, the hearing is not required for appointment.
along with my lord, this
In charge, there's no in charge kind of thing.
no,
We are not interested in charge business.
along with my lord,
You read the page 38, it's just a notice to hearing.
that is on the basis after my lord.
They are fair enough to hear you before decide.
My lord, on the date of hearing, my lord, this objection has been raised that my regularization has been given with immediate
Where is the
effect.
order?
My lord,
What is the final order after hearing?
even my lord, with page 28 also I have challenged that, my lord, because
When you were heard? When you were heard? When you were heard?
my lord, last, my lord, page 38 is the last communication. My
That's all.
lord.
You have been heard.
Yes, ma'am.
That's all. If you are aggrieved by any order, you may.
No, my lord, I
Fine.
also agree by.
How can you say that you will not be? You should not be heard. Normally, people come and say that I have not been heard.
No, that's true. my
You are
lord.
just the ulta.
No, well, even if page 20 also, 28 also, where I have given.
Doesn't
my lord,
matter. It's not. It's a regulation for your substantive post.
other similarly situated person might has been given from the date, initial date of joining, my lord.
We don't know.
Well, it is, I have annexed the orders, my lord, of the other regulations.
We're not interested. You are preempting. You are trying to preempt.
Since hearing was already done, my lord.
Withdraw. Dismiss otherwise.
My lord, at least let them take instruction.
No,
of the
no
hearing.
instruction, nothing.
My lord, apart from the notice.
How can you ask for, modify the order of 2005?
My lord, that is raised during the, my lord, promotion.
No, sorry.
Promotion process while, my lord, conducting that issue has been raised now, my lord, by the department. That's why, my lord, I have. No, my lord, I have raised the objection, that is, I have mentioned in my pleadings, my lord, that was not corrected till that much. Because of my lord, this 2005 order, my seniority has been affected, my lord.
It's up to you whether you will withdraw or will dismiss the writ petition. No instruction required. Basically, you are challenging the notice for hearing.
Hello.
Normally, people wants that, I mean, they should be heard. We have not been heard. Violation of principle of natural justice. You are saying, you are coming with different thing. And then we cannot direct the petitioner, the respondents to modify your regulation order, which has been done in 2005. How many years now?
Lord, since it's 20 years, my lord, I have continuously processing, my lord, for my
Doesn't matter.
modification of.
There is a
petition, my lord. They
judgment
have
of the
not-
Supreme Court. Representation after representation will not give you a right.
On 6/5 hearing was conducted, thereafter, my lord, I have, what happened, I don't, my lord, as per instruction, my lord, they have raised this objection that my regulation.
It's
has
not
been-
an issue.
Lord, let me take instruction on after hearing what has been updated, my lord. I'll.
See, essentially, you have challenged the notice of hearing. Did you appear?
Yes.
Better ends there.
My lord,
You, if it is not this thing, I mean, not palatable to you, if it is, you have not been, you can challenge that. We'll provide you that.
my lord, let me take instruction on that.
What
issue, my lord.
instruction?
My lord, after hearing any
No,
order
no.
has been passed
No,
on, my
no.
lord, that I'll, my lord, bring on record by filing additional affidavit.
No, no, that cannot be. Will not allow. When your primary challenge is to the notice for hearing, and when you have appeared, nothing remains.
Well, along with 2005 order, I have challenged, but that
That
was.
you cannot. That you
Even,
cannot.
well, as per my instruction, they have, CS.
Why don't you try to understand, sir?
CS continuously filing the applications for.
And Mr.
rectification.
So-and-so, land counsel for the petitioner. List the matter and after 4 weeks for the parties to obtain instruction as the primary as the petitioner has essentially challenged the notice for hearing, which this court prima facie finds that no challenge could be made to such notice for hearing. Could have been made, huh? Please stop.
There is an interim order, my lord.
What interim order?
One post was kept taken in the last. For the service.
Why one post?
Till the, my lord, next date, my lord.
I don't know why. What sort of interim order was there?
For
You are
the,
challenging the order of notice of hearing. Huh? Huh? I don't understand. Why this order has been passed? You file a petition applicant for vacating in this order. Can't help it. Interim order passed, let's continue.
I'm highly obliged.
27.
Made your lordship. Before lordship is a limited pair, my lord. Petitioner is all retired from service and his departmental proceeding is pending, my lord. So, my lord, he praying before your lordship for provisional pension. Is it mandatory to allow the petitioner to give the?
Huh?
My lord, honorable court held that, my lord, the provisional pension is a mandatory the section rule 22 of the Assam Pension Rule 1969. And that will be adjusted the final pension minor. So I pray before Lordship to allow him to provisional pension minor.
Under consideration.
Yeah.
It's under consideration.
That may
They'll
be-
consider.
that allow him.
Heard Mr. N. Bora, learned counsel for the petitioner. Mr. Next para, Mr. This is only for payment of provisional
Only
pension.
provisional pension and GPF. This is the GPF is the property matter. Others I am not praying matter.
Next para, Mr. P.K. Bora, learned standing counsel. Elementary by placing the instruction. And then placing the copy of the communication dated 15/06/2026 from the Deputy Secretary to the Government of Assam Department of Skill Education submitted. The claim of the petitioner for provisional pension is under consideration. Therefore, prays for 2 weeks time to obtain the necessary instruction or to obtain further instruction. Lord, list this matter after 2 weeks.
My PR is directed to allow me to the
Suppose if we pass this, it will amount to passing the final order.
As per rule 22 that the mandatory.
It's okay, they are under consideration.
But because of two daughters is out
Okay.
of my
2 weeks, that's why we have said 2 weeks. You bring it on 2 weeks. List the matter on 26.
That process may be completed within a period of 2 weeks.
We don't
that
know.
may be because it is a mandatory. Your Lordship is that.
Okay, thank you. Next.
Otherwise,
26. We have fixed it, given you a preference. Sir, try to understand.
But problem is that this is the mandatory. That should be done.
So-
By law. But how he runs.
So how the heaven will not fall within 2 weeks. That's why we fixed it. Without you asking, we fixed it for 26. Please try
Right.
to understand, Mr. Bora.
Fix a date, my lord. 27.
You are making match
My lord.
commission without hearing the order.
My lord.
Yes,
The Lordship.
yes.
Lordship, this matter pertains to provincialization of service.
Hmm.
The petitioner has been working as Arabic teachers in
Yes.
school under Lakhimpur district.
Yes.
Lordship, on last occasion, instructions has to be brought by the respondent authority.
Mm. Huh? Why? Provincialization of your service as
Pardon, Your Lordship?
Arabic teacher.
Yes, Your Lordship.
How many teachers have been provincial in your school? Under what provision? Anyway, we'll grant them to file affidavit. Heard MS so and so learned counsel for the petitioner. Your name, please.
A. Sharma.
As and learned counsel for the petitioner. Is grateful by Mr. MS as the rank with London Standing Council. Secondary education. Further 3 weeks time is granted to file affidavit in opposition. Yes, next. Contempt.
Yes, Martin.
Are you filing? Are you complying? Okay, heard Mr.
F.U. Bolbu, Your Lordship, sort out.
F.U. Burbuya, learned counsel for the petitioner. As prayed for on the prayer of Miss SMT Sistit, learned counsel for Alice Contempt further, let this matter be listed after 3 weeks for compliance of the compliance, for placing the compliance order, for playing the compliance order, compliance order.
I am praying for fixing a date, Lordship.
3 weeks, be happy.
Obliged.
31.
The response number 10 minutes, I have filed an NPD.
Yes, that we have seen already. Then 4, 5, 6, 7, 8, and 9. Nobody.
They did not, my lord.
Heard Mr.
BK Sen,
BK Sen.
the lordship forgot my name, my lord.
No, 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 no.
Yes.
I just wanted to hear from your mouth
I,
because you are sane and always sane say. Is not it?
well, your lordship,
Learn next.
lordship, remember, my lord, Ashok Sen,
Ah.
he was the president of the Supreme Court Bar Association.
Ah.
Your lordship, remember.
You are related to him.
Distant,
Huh?
distant related to her.
I happened to, as a lawyer, I had a privilege to appear with him before the Supreme Court.
I see.
We have engaged one matter with him. I think somewhere in 2011 or 12. I've been to his place. He's no more.
He is no more now.
But here in Gauhati, SK Sen was the senior.
SK Sen was also.
Yes, yes, I know. I know. The saints are always sane and they are always great. They can never be not great. They are always great. Okay. And Mr. BK said learned counsel for the petitioner. Mr. A. Chetri learned counsel for the B. Chetri, sorry. Learned counsel for the respondent number 10. Submits that he has already filed the affidavit on behalf of respondent number 10. Then rest. As prayed for by Mr. S. Das, learned counsel for the learned standing counsel, higher education department, for respondent 1 and 2, as well as Mr. Y.N. Mohanto, learned counsel, appearing on behalf of A. HMO, learned counsel for respondent 3. For the 3 weeks time is granted to file affidavit. Yes. What is the matter about?
That relates to Millard selection and appointment of the principals in different colleges, Millard, in violation of rules.
Okay.
But that is the crux of the matter.
Election of what?
Selection of Millard principal
Okay.
in different colleges of Assam.
Okay. I thought election. It's a selection.
Selection.
I
Not
mean,
election.
I was wondering.
Yes.
I mean, how the principals are elected in the colleges in the Assam.
Selection, Millard, not election.
Election.
Election is Millard in West Bengal. There are so many election petitions
Okay.
are filing before the Calcutta High Court.
Has already been decided by the Son.
In the present matter.
That your lordship, Millard, I'll satisfy as to whether, Millard, we have got a good case on merit. Millard, I'll
Okay.
satisfy on that. Let them file affidavit, Millard.
Yes,
we have
yes.
To respond. on
Yes.
Also, will fix that after.
After 3 weeks or 4 weeks?
After vacation, Millard. After vacation.
Make it 4 weeks.
4 weeks, yes.
That may be.
I am obliged, Millard.
31st July.
31st of July.
Why? And it's not possible. It's not possible.
Why is not possible?
Already, this honorable court.
Already we have picked so many matters before 31st.
The issue has already been decided by the honorable court.
Therefore, we'll take it up on 31st.
I am obliged, Millard. Deeply obliged.
33.
May I please, Your Lordship?
Yes.
What's the similar issue has been settled by the coordinate bench in a bench of writ petition, my lord?
Yes.
Oh, I've. The advertisement is same, so against the same advertisement they have applied for, my lord.
Yes.
Exactly similar, same issue.
Yes.
Give them upon due verification. If they similar order as paragraph 19, page 30. Upon due verification, the state authorities to basically may not utilize manner, whether they fall under the requirements.
The similar order may be passed, my lord.
The upon due verification is related.
All are represented.
My lord.
They have some orders.
That's what I'm saying.
What party one is? That's all are represented, I think. NS notice one. One ID. So good, sir. Huh? Kone kone appear করছে? 80%. So as per my instruction on the motion day itself, they have appeared, my lord. The respondent number 5. And basically the main party is the education department. He is present. Elementary education.
What is your prayer here?
Prayer is basically for setting aside the notice dated 19/11/2025, whereby it was directed to produce the NIOS UDIS code, my lord.
Particular to you?
Partic-
1911.
Yes, particular to the candidates who are having 18 months diploma holder, my lord. Diploma in elementary education holder.
So this orders has been, it was a common order or?
It's a covered order.
No,
because
common order or this notice was a common notice?
common notice.
That has been set aside.
Yes, my lord.
Common
That was not set aside exactly,
Huh.
but that was molded and passed this common.
Paragraph 16, 17, 18, and 19.
Mayor,
Thereby not-
move there.
thereby not inclusive. Cannot be counsel for the NIOS, paragraph 15, page 32.
Hmm.
Thereby not counsel for the NIOS appeared and submitted that the entire process of obtaining diploma in elementary education was conducted through online mode.
My lord, the relevant part is I'm reading. The para 19 basically. This is the operative part and the relevant part also. In view of the
No, what is your facts here? You are also seeking appointment.
yes, the facts is similar, the facts is same, the advertisement is same, the requirement of NIOS UDIS that is also same for 18 months DLED course, all are same, all are similar to this order, my lord.
Same.
Same, exactly ditto, my lord. I can say that.
The same advertisement.
Same advertisement, same notification.
Same notice.
Yes, same notification also. This 19.
Where is that notice?
My lord, the notice is at page 74. My lord.
I don't know. 1911.
Yes.
Yes. So this.
So by this notice.
This 76. Okay. You are service candidates.
In service candidate, yes.
In service candidates. Serving as?
Serving as, my lord, in a assistant teacher in lower primary and upper primary school. In a private school, basically.
So everything is ditto.
Ditto, my lord.
So, my lord, this was the consequent can be 15, 16, 17, 18, and 19. Those are the current what we verification. Paragraph 15.
So ditto. Same. Heard, mister?
BM
Then we'll dispose of.
BM Decca, my lord.
BM Dekha, learned counsel for the petitioner. You are here in this matter.
Yes.
Okay. Learned counsel for the petitioners. and also heard Mr. A. Pukon. Learned Standing Council, Elementary Education, correspondent 1, 2, 3. Then your name? TSK. I Alam. Learned Council for respondent number? NCT respondent. Who is NIS?
R Bora, RB Bora,
RB Bora. R Bora or RB Bora?
RB Bora.
You will record his name. You will record his name, her name.
She applies for NIL.
Will record her name.
Maybe like
You just inform and let
I will inform my lord.
Otherwise, you will say non-appears and so and so. You just inform and inform the court
I'll
martial.
do that.
Next para. Having considered that having considered that the similar matter has been disposed of by the coordinate bench of this court and as agreed to by learned counsel by the parties, this writ petition is heard and disposed of at the ordered state itself. Then madam, you take the facts here. Then you write this. You are working as?
My lord, working as a in-service teacher in private school, my lord, as an assistant teacher.
Okay. Facts are same?
Facts are same.
Everything is same?
Exactly, my lord. The notice are same, advertisement is also same.
Then you take it from there and the coordinate bench of this court in the case of in the last paragraph after the facts, by an order that is 04/06/2026 in WPC 4842 of 2026. Within brackets, Suraj Sharma and others versus State of Assam.
Yes.
Bracket close, As
Question.
as considered. That will be last, and disposed of the a similar method. About the relevant paragraphs which are reproduced herein under, It doesn't indicate the date of notice.
Yes, my lord. At para 7, page 29.
Where is that? The date of notice is mentioned in this order?
19, para 7.
Paragraph 7
Yes, my lord.
of the order.
Yes, of the order, my lord. At page 29.
Okay, 1911.
Yes.
Same. Then you quote the paragraph.
My lord, basically all are all the
Reproduce
facts are same.
reproduce the paragraph. It
Well, paragraph 3, paragraph 4,
It's okay.
paragraph 5.
Yes, wait. Pero 10, 11, 10, 11, 12, 13, 14, 15, 16, 17, 18 and 19. You just reproduce this one. Huh? 11 to 19, you reproduce.
Much obliged.
The article of investment property.
Huh?
May I please, Your Lordship?
Yes.
Item number 34, my lord, I may be allowed to withdraw this petition, my lord.
Mr.
A Gauhati.
Go ahead, learned
With a liberty to file a
learned counsel for the petitioner, same step. He has an instruction to withdraw this writ petition with a liberty to file afresh. Therefore, praise for withdrawal of the same. Next, Mr. A. Fukon, learned standing counsel. Secondary, elementary education department is present. According to the writ petition stands closed on withdrawal with a liberty as prayed for. Continue. Please.
May I please?
Yes.
My lord, this case, my lord, relating to my lord, non-payment of my lord, area stipendary granting aid, my lord, the petitioners, my lord, with effect from 1997, my lord. My lord, the case of the petitioners were, my lord, were answer teachers, my lord. Subsequently, my lord, the BTC or BSc authority, my lord, by divine order, my lord, petitioners were appointed as, my lord, council as teacher, my lord, with a, my lord, stipendary granting aid of rupees 900 per month, my lord. My lord, my lord, appointment of some petitioners, my lord, I have an as my lord at page 37, 38. My lord, kindly see my lord, appointment letter. My lord. In the appointment letter, it is specifically mentioned that, my lord, in persons of instruction of BSc so and so, this so and so is hereby appointed to act as assistant teacher of so and so school under the subdivision of Bizni in district of Boiga under BSc area at the fixed stipendary granting age of rupees 900 per month with effect from 1/11/1995 till provincialization. My lord, accordingly, my lord, we were, my lord, we had been researching our duties, my lord, in the said capacity, my lord, and accordingly, the competent authority, my lord, released, my lord, stipendary granting aid, my lord, for 18 months, my lord. That is, my lord, with effect from, my lord, 1/11/1995 to 34/1997. Thereafter, my lord, suddenly, without any notice, my lord, the payment has been stopped, my lord. Thereafter, my lord, a batch of, my lord, petitioners, my lord, of course, before this honorable court, my lord.
You have filed 2 writ petitions earlier.
My lord.
2 writ petitions.
Yes,
This
sir.
is third.
Yes.
Fourth.
This is third, my lord. Third time, my lord, we filed contempt petition.
This is third writ petition.
Yes, my lord. This is third petition, my lord. During pendency of the, my lord, writ petition, my lord, the respondents were directed to, my lord, consider our case, my lord. Thereafter, my lord.
When your services were provincialized?
My lord, kindly see, my lord, page 37, my lord. Annex 1. This is one appointment of one petition, my lord.
How many petitioners are there?
Petitioners are, my lord, 120, my lord.
Assistant teacher.
Yes, my lord.
Huh?
Yes, my lord.
Under this of the business, all under business.
No, my lord, within, my lord, BTC area, my lord, different area, my lord, from within BSc area, BTC area.
Then when you were Service was regularized?
No, my lord, service was not regularized, my lord. My lord,
As on today, you have not.
no,
been
my
there.
lord, as on today.
You still is working.
Yes, my lord. No, my lord, some of the petitioners, my lord, their service got provincialized in terms of, my lord, Venture Educational Institution Act, my lord, and some already got retired, my lord.
So what do you want?
My lord, my prayer is, my lord, our prayer is, my lord, since we had discharged our duty in terms of this appointment order, my lord.
There are how many appointment orders?
My lord, we have annexed, my lord, only 5 appointment orders, my lord. Other
Then what
appointments-
about others? How
Others
do
will
you
be-
know that you are appointed?
My lord, same day, my lord.
Huh?
Same day. Same day. Same day. Since, my lord, we had served our duty, my lord, but we have been, my lord, granted only, my lord, 18 months, my lord, estimated grant in it, my lord. Thereafter, my lord, suddenly without any notice, my lord, without any termination, my lord, we have, my lord, respondent stopped to make payment, my lord. Therefore, my lord, the petitioners approached before this honorable time and again, my lord, and the honorable court also directed to consider our prayer, my lord. But till that, my lord, nothing has been done. Finally, my lord, the impugn order, my lord, dated 29th May 2022, my lord. Our
Page?
page, my lord, 170, my lord. This is the impugn order, my lord.
You are appointed for only
My lord, till
18 months.
no, my lord. In the appointment, not for 18 months, my lord.
Let us see the appointment, page 37.
Page 30, yes. Sir. My lord, in pursuance of instruction of the BSc, Professor so and so, and so and so, so and so, is hereby appointed to act as assistant teacher
of so-and-so school, LP school, under the subdivision of reasoning in the district of Bongaigaon under PSC area at the fixed stipendary grant in 8 of rupees 900 per month with effect from 1/11/1995 till provincialization of his or service, my lord. So, my lord, at that time, my lord, we were answer is this, my lord.
So from since you are claiming for 1995.
Yeah, 1997, from 1995 to, my lord, 30 April 1997, 18 months, my lord, grant in 8 has already been paid, my lord. We received, my lord. Thereafter, my lord, the respondent authority stopped to pay, my lord.
You served or not?
My lord.
Are you still serving?
No, my lord, yes, my lord. And, now we already, my lord, some of the petitioners' service got already provincialized, my lord. And some of them already got retired, my lord. Therefore, my lord, our prayer is, my lord, since we have been working from 1995 to till, my lord, provincialization, my lord. So during that period, my lord, the respondent authority bound to pay my lord granting stipendary, my lord. Since, my lord, we have been, my lord, discharging our duties in view of the appointment order, my lord. But without paying the area salary, my lord, did nothing except, my lord, this impugn order, my lord. Even, my lord, in the impugn order, my lord, itself, my lord, there is no any whisper, my lord, when they terminated and when they stopped this policy, my lord, there is no any mention, my lord, to that effect, my lord. And in this regard, my lord, fight order dated 9/9/2025, my lord, is honorable for, my lord, court directed the respondents, my lord, to obtain instruction, my lord, as to when the policy has been discontinued, or, my lord, kindly see the order dated 9/9/2025, my lord. This is judicial order, my lord, that has not been complied with, my lord.
As to when the scheme of providing stipend to the Bensal initiative monument project discontinued, the same is still in force in celebrating. Yes. What does it say? Fixed period for what? Appointment order doesn't say anything. Huh? (1997) to which year?
Till provincial, that is, my lord, 2013, my lord. 2013, as per Act 2011, my lord, 2013 provincial was done, my lord. 2013.
For 900 rupees?
Yes, my lord. Only 900 rupees, my lord.
There was a scheme of providing stipend to Benson LP School. Have you gone through this 099-2025? Further. It's okay. There's no question. What they are asking is that the stipend of rupees 900 per month from 1997
Yes,
to 2000 till
from May 1997
provincial 2013. They are not seeking for provincialization.
Yes, that part also already, my lord.
But what they are saying is, it was granting aid.
My lord.
This government has stopped the granting aid.
Yes.
Therefore, they cannot pay you because there is no policy to continue it. How can you be
my
allowed
lord,
to continue?
when they, my lord, if that be so, my lord, we ought to have been, my lord, informed, my lord.
Huh?
We ought to have been informed, my lord. since we had been continuing our duties, my lord, they appointed us, my lord. Thereafter, without any, my lord, notice, without any reason, my lord, salary has been stopped, my lord. Is it fair, my lord? It is totally unfair, my lord.
They are in the knowledge of the petitioners also, and for each criteria, they were appointed and subsequent worship. And this has been done in 1997. When PSC was there also. So hereafter, there are no constitution has been taken by the all the orders by the
My lord, respondent take a ground, my lord, that, my lord, belatedly, my lord, we claim our, my lord, arrears salary, my lord. How, my lord, we had approached before the Honorable High Court, my lord, way back in the year, my lord, 2003, my lord. Thereafter, continuously, my lord, our action is going on, my lord. So where is the, my lord, question of delay, my lord?
But how you are entitled? When you are appointed as a stipendary teacher on the on granting aid,
My lord.
when there is no granting aid, from where they will pay?
No, my lord, if
They
there
have
is
no- There is no policy decision.
there is no policy decision, my lord, only mayor saying, my lord, there is no policy decision, but my lord, to that
Where is
effect-
the policy? Do you know any policy decision?
No,
Have
my
you
lord,
brought-
I don't know. It
Have
is
you
the
brought
duty
on
of-
record?
No, my lord. It is the duty of the respondent, my lord, when the policy decision, my lord, has to post or my lord, end, my lord. And to that effect, my lord, Honorable High Court also, my lord, directed to obtain instruction in, my lord.
Yes, last order 9/9/2025. You're directed to obtain instruction. Where it is? When did you file?
Affidavit file, my lord. My lord, there is no whisper, my lord, to that effect, my lord.
Hmm.
No whisper, my lord. And interestingly, my lord, the impugn order, my lord, issued by the, my lord, Commissioner Secretary, my lord, Elementary Education, my lord. My lord, the Commissioner Secretary has not filed any affidavit, my lord, to
Who?
that effect.
Who has not filed affidavit?
My lord, the impugn order, who issued the impugn order, my lord.
Hmm.
He is the respondent number one, my lord.
Hmm.
Commissioner Secretary to the Gauhati Elementary Education Department, my lord.
Hmm. So,
He did not file any affidavit, my lord.
do you dispute that they have served? They have served. What is your stand on that in your affidavit?
Nowhere restricted, my lord. My petition, my lord, paragraph 3, my lord, I have stated detail, my lord.
What's wrong with the impugn order?
My lord, impugn order, my lord, impugn order has no basis because, my lord.
It has the basis.
Merely, no, my lord.
You are appointed on stipend basis.
It is admitted position.
Then-
yes, my lord. We have been appointed.
How do you say that? How from where you are saying that you have been allowed to continue?
No, my lord, appointment order itself, my lord.
It's okay, no, it's
My lord,
says many things.
Till provincialization. My lord.
How you are,
My lord, our
you do
service-
have any record to show that you
our
have, you have
service
continued?
provincialized, my lord, in the year 2013, my lord.
Hmm.
Then, my lord, before 2013, my lord, we are entitled, my lord, in terms of the appointment order.
The appointment order is not for you, it is a granting aid. You are appointed on stipend. Stipend
Yes, my lord.
shall be paid from the granting aid. When there is no granting aid, can you force them to provide
No, my
granting
lord,
aid?
we cannot force, my lord, but my lord, respondent,
See, it's not your appointment is not the kind of any regular kind of appointment, normal appointment. It's not it's
is true, my
based
lord.
on stipend, I mean,
but
granted
my
aid.
lord, we respondent, my lord, used and throw policy, my lord.
It's not that. See, it's
because-
not that
Because my
when
lord,
you are admitted that your payment of stipend is subject to providing granting aid, not from any other source. Then when there is no granting aid, how can you be paid?
no, my lord, granted, if there is not available, that ought to have been informed, my lord, that
It's
now.
not information, is
the
not
policy
that.
has
No,
been
no.
closed down, so my lord, so.
See, granting aid means what? It's not a regular flow of fund.
We have to be,
It's
my
for
lord,
particular
my lord, informed
scheme,
us,
it's
my lord,
for particular
because, my
period.
lord, with that
It's up to
expectation,
the
my lord,
government that you should be given or given or not.
Since we were
You,
there-
as a matter of right, you cannot say that
See-
this should be granting aid. And when there is no policy, they are saying that there is no policy.
Since, my lord, in view of this.
There was
my
no
lord,
policy to continue.
my lord, when not continued, my lord, when discontinued, that part may be, my lord, ascertained, my lord.
Huh?
That part may be ascertained by the respondent, my lord, when this policy was discontinued, my lord. My lord, since we are, my lord, in view of this appointment, we had our.
You have retired, be happy.
Yes,
Your
that
service
is
has
true, my
been,
lord, but
your
we are
service has been regular, provincialized.
We are
Why
entitled,
it is?
we are entitled, my lord, during.
You
this
are not
period.
entitled.
Because, my lord, without any
Sorry.
information, we were used by the respondent, and now, my lord, they do not want to pay, my lord. It is not, my lord, it is totally arbitrary, my lord.
What arbitrary?
My lord,
Yours is not a normal appointment, sir.
that is true, my lord.
This is based on, it's subject to granting aid.
Granting aid, yes,
When
my
they have already discontinued.
Yes,
Who
my lord.
provides the granting aid?
BSc authority, my lord.
Huh?
BSc authority.
Not at all. By the government. And they said that they don't have any responsibility. BSc has no responsibility to continue to provide granting aid. The moment the state government of Assam, government of Assam discontinued, it was discontinued. For 18 months, there is a granting aid, therefore you are paid.
That is it, yes, we also, my lord, in our repetition, we stated that we have received, my lord, 18 months granting aid.
Because there was a granting aid. There was thereafter no policy, nothing to provide, and in fact, it was discontinued.
Then, my lord, earlier batch of petition, when we approached before the honorable court, my lord, in the year 2000.
That was, they have directed you to consider. Your case has been considered.
Next, my lord.
Your case has been considered and rejected.
In the year, my lord, 2015.
And rightly done so.
In the year 2015 also, my lord, we approached. Then also they keep silent, my lord.
Now finally they have. Finally, they have decided.
Such type of, my lord, action is not, my lord.
Just your nature, the nature of appointment has to be looked into, sir.
It is.
It's not that you have been regularly appointed and stop payment and thing. This is based on your granted aid.
Appointment does not say that.
It doesn't say, or no, when you are admitting that yourself.
It is not.
When you are admitting yourself that it is grant based, the payment are on granted aid. From granted aid, how can you? I would say that the appointment doesn't indicate.
But, my lord, in the appointment, it is not stated that it is this appointment is only for 18 months, my lord. It is continued till provincialization, my lord.
No, till when and based on your payment will be made on granting aid, from granting aid. When there was no granting aid, then how, from where they will pay?
That should be informed, by, my lord, ask my lord.
It's okay, now they have considered and disposed of.
The policy decision is discontinued.
Hmm.
It should be, my lord, informed earlier, my lord.
But then,
which has
but
not
then
been
you
done, my
have
lord.
continued without any this thing, and then your services have been provincialized.
We approached before this honorable court one after another, my lord, and earlier occasion they, my lord, totally keep silent. Now, my lord, they say, come.
Mr. Mr.
A. Hussain.
A. Hussain, learned counsel for the petitioner. Having considered that this, after hearing the matter at some length, it is found that at some length, it is found that neither the petitioner nor the respondent has clearly brought on record as to whether the payment of stipend was based on, was to be from the granted aid from the state of Assam, which has been discontinued, or whether there was any scheme providing stipend to the teachers of to provide Benson LP school was discontinued or not by the actual, what is this? Bodoland Autonomous Council, now BTC.
Now BTC.
Now BTC.
Bodoland Territorial Council.
I'm of the considered view that the respondent BTC to bring on record to obtain instruction and bring on record the scheme of bring on record as to whether the scheme of providing stipend to Benson LP school initiated by the actual BSc, now BTC, has been discontinued, or whether there was any, any other scheme has been framed and also as to how the petitioners were continued in the service as stipend teacher. List of, accordingly, MS and Chaudhary learned standing council BTC to obtain the instruction as directed in the above, and as observed and as mentioned, is that the required instruction by filing by when affidavit. This the matter after 4 weeks.
Already we have stated in our writ petition, my lord. So what documentary is
Before
required?
that, the petitioner is also directed to bring on record any documents to establish of their continuation as a stipend teacher since from 1997 to till
13,
the,
2013.
the still the provincialization of their services. You also bring,
My lord,
you may say many things, but it has to be substantiated.
36, 37.
actually, my lord, third round of litigation. And initially the single bench granted us relief. Thereafter matter went to division bench. The division bench also granted relief. And then again they did the same thing. And then we had to come before your lordship. In fact, my lord, by one of the orders, senior counsel B. Bhuya was appointed as an amicus. If today everybody is there, we can do the matter, or my lord, we can have it after the vacations.
Vacancy of what?
My lord, these were students of Sainik School, Gwalpar.
Still there. Still issue survives.
My lord?
Still the matter survives. Or?
Yes, yes. They are studying. Studying. It was 12. But one is studying in class metric. Metric decision. Can I have it after the vacation?
You withdraw everything. What's there? But then once you withdraw everything in the interest of the so you are not taking any action. So if you are not ultimately, if it is suppose, if we find that even if we accept your submission, that will not interfere with the as regards the discipline of this disciplinary proceedings of the school, what will be the effect? They will be terminated. They will be terminated. They will be terminated. Then ultimately it will have a effect on the academic, the career of the students.
Girl is still studying. She is, I think, in class 10. Matriculation. Board examination is.
Okay. Mr.
A.K. Borua.
A.K. Borua, learn counsel for the petitioners. Matters, huh?
Actually, this was my lord CEV for a long time before my lord Justice Jamir was there, but then my lord he had to transfer from Gauhati High Court.
What do you want to say?
No, my lord, that's
Is agreed to by learned counsel for the parties list these matters after
vacation, my lord.
After 6 weeks.
After vacation.
4 weeks. 4 weeks.
38th, my lord. 32nd.
On 30th, 07, 2020. Make it 30th, what's it?
30th. No, there's an interim protection, my lord. That
Interim order passed, and let's continue.
obligement, deeply.
38.
Why? What is the matter about?
Yes, madam.
We have filed the affidavit. Then
Kindly see impugn order, my lord, page 99.
rejection.
Yes, my lord. It's a third round litigation before this honorable court, my lord.
Why
I
third
had
round?
no question because only my lord, some discrepancy in the name. His name has not been, my lord,
Pursuant the High Court ordered there is a person on the matter of publication. Mofizuddin Ahmad. Your name is
no, my lord, next one, my lord, Muhammad Fazlul Haq
Model
Mandal.
Fazlu Haq. Huh?
Yes. He was appointed on, my lord, 16/5/1999 in the said school, my lord.
Hmm?
And my lord, in the dice code, his name also appeared, but in somewhere, some, my lord, spelling wrong is there.
Fazlul Haq Mandal is not available in DISC. Hmm. From where your name is enter is shown in the dice. You have
Yes,
the
ma'am.
dice code. Where
Ye-
it?
Yes, Lord, should we kindly see page 33.
Hmm.
We have annexed some dice, my lord. It will start from, my lord, page 30,
33.
29, madam.
Where is your name?
Lord, should we kindly see, we have annexed,
Jasimuni
Page 30.
Puran Kechu Mem.
my lord, page 30.
30.
Yes, my lord.
Hmm.
Here appeared, my lord, Fazal Haq.
Huh?
Fazal Haq.
Fazal Haq. Your
Yes.
name is
My complete name is
Fazlul Haq. Then
Fazlul Haq Mandal, Lordship.
so
Thereafter, Lordship, may kindly see page.
this is
another-
Fazal Haq.
Yes, that page 33.
Huh?
Page 34. This is a dice code of, my lord, 2010. We type it, my lord. And page 34 is the my relevant question, my lord. Here also appeared Fazal Haq.
Where page?
Page 34.
34.
Yes, my lord. Here,
Fazal Haq.
Fazal Haq, my lord.
Hmm.
Thereafter, Lordship, you also annex.
What is your date of birth?
My lord, my date of birth is. Some report is there, my lord. It will, Lordship will find.
No, do we have the date of birth? That's why I'm asking.
Lordship may kindly see page 54.
Any
One-
proof of your date of birth?
My lord, it is their record, my lord. Lordship may kindly see. Date of birth, my lord.
Of the
17/5/1990. No, this is date of joining.
Muhammad Fazul Haq Mandal.
Yes, my lord. It is their document, my lord.
Hmm.
That is correctly recorded, my lord. And date of joining also, my lord.
I don't know date of birth I am asking.
Yes, my lord. We are checking, my lord.
Fazal Haq.
Mandal.
But your name is Fazul
And-
Muhammad Fazul Haq Mandal.
Fazlul Haq Mandal.
Huh?
Yes, my lord.
Yours is, this is Puzzle Hawk. Page 33, 30 and 34, Puzzle Hawk,
Yes,
not Puzzleul.
yes, that is some discrepancies there.
How?
It's my lord, we have subsequently, my lord, forwarded through the headmaster, my lord. We have made party also headmaster, my lord. He has not appeared, my lord.
No, no, you first establish that your name is Puzzleul Hawk Mandal,
That's why, my lord,
not Puzzle Hawk.
I have shown
And,
that.
and you show that your name is Puzzle Hawk, not Puzzleul Hawk.
My lord, other than.
What is the recommendation?
See,
What is the recommendation?
yes, index.
DLC report page 59.
Page 59, my lord.
What is your name?
Yes. Mandal, my lord, last page 60.
Hmm.
My lord, it's a serial in the middle portion, my lord.
Puzzleul Hawk,
Mandal.
Puzzleul Hawk Mandal. Who is this is recommended by whom?
It is my lord, chairman district scrutiny committee, my lord.
From where will you get?
It's a seal is there, my lord, in page 60.
Where is the recommendation? Particulars for
Particular, yes,
professionalism,
ma'am.
high
Government
school
is set.
instance. Then why your name has not been mentioned in DISC code, DISC code, DISC code?
Yes, my lord, this is maintained
There's
by the
data.
authority, my lord.
Ah.
So,
So if it is not shown, it is one of the requirement for
yes,
provincialization.
so we submitted it, my lord, even after correction submitted for the headmaster, my lord.
Who will correct this, the data?
My lord,
DISC data, who will correct it? Not
It
the
is-
headmaster.
not the headmaster, my lord.
This is
You will
maintained
submit-
by NUEPA, New Delhi. So until unless you get it corrected, showing your name in the data, how you can claim that you are entitled?
So we have submitted through headmaster, my lord. In pleading, we have
No,
stated.
it's not recorded. So rightly they have rejected your case. Are you admitting that the name has to be in the DICE code?
Yes, my lord.
Your DICE code number has to be there in the data.
We have
It has
shown-
to be.
Yes, in the dice code, my name is there, but
How?
some mistake is there, my lord. Spelling mistake is there.
No, that cannot be. Your name is not there here. That's the reason. It's not a spelling mistake of the name.
But
Your rejection is on the base of on the ground that your name is not shown in the DICE data.
11, 12. Lordship may kindly see we have annexed this 11, 12 dice data, my lord. Page 37, my lord. Here appeared my name, but it is wrongly, my lord.
No, that cannot be, sir. Name has to be there. Since your name is something different, if it doesn't appear,
So we are saying that.
how
my
do you,
lord,
how do you,
Puzzle Hawk.
puzzle hawk may be different.
My lord, it is, this was
37, where it is?
subsequently
School
corrected.
code. Huh?
Subsequently,
Where
was
it is,
corrected.
where is the DICE code?
My lord, page 37. We relevant portion, my lord, we have given page 38. His name appears as Puzzle Hawk.
That's what I'm saying. Was Puzzle Hawk could be there. Your name is Muhammad Fazlul
Hawk Mandal.
Hawk Mandal. This name is Fazil Hawk.
My lord, thereafter it is subsequently in the year 2020-21 it is corrected, my lord.
Where? From where?
We have annexed some document, my lord.
Who has corrected it?
It is corrected through headmaster is submitted to CRC, my lord. We have made party also then.
Making a party is not
The
enough.
mission director, my lord.
Who has
That-
to correct it? It has been
That-
corrected.
No, they have not corrected.
Then your rejection is proper.
Corrected as a positive hawk. Mondol is not there. Once it was corrected.
So ultimately not corrected fully, my lord.
Until it is corrected, you go and get it corrected.
So our
See, your rejection or provincialization rejection is only ground that your name doesn't appear in the dais data.
yes, my lord.
Therefore, maybe the name of Fazil Haq may be there, but your name is Muhammad Fazlul Haq Mandal. So unless you get it corrected, maybe a mistake, genuinely your name might have been inadvertently spelled,
Yes, my lord.
wrongly spelled. Now, unless it is corrected, you cannot challenge this.
So we have submitted.
You have not, after you were also heard in the appeal, you could not submit any documents to show that your name appears, in fact, in the DICE data. So unless this time, we cannot help you out.
My lord, there is school document, lordship, page 54, I have shown lordship. Here correctly appear is there. Lordship,
Page
it is-
54.
Yes, my lord. And my lord, date of joining, then other things, all are correct, my lord.
All may be correct, but it doesn't appear. Muhammad Fazlul Haq
Yes, my lord.
Mandal.
My lord.
Then this is order of 2008.
Yes, lordship, page 55 also
The
lordship.
following so-and-so committee has been appointed by the managing committee records. We are not questioning it, but one of the criteria, I mean the requirement for provincialization of your service, that your name has to be mentioned in the DICE data.
Yes, my lord.
Since someone's name is there,
Okay.
which you claim to be wrongly spelled or wrongly mentioned,
Mention lordship.
we cannot say unless you get it corrected through proper, I mean, by the competent authority.
Yes, my lord.
So,
But my lord, their rejection, my lord, my case is that it is the authority who are maintaining the record.
it is your duty when you come to know that your name has not been recorded
We inform the
or wrongly
headmaster.
spot.
We inform the headmaster and.
No,
also
headmaster is not, who has
It
to
is-
correct it?
It is routed through a headmaster place.
And you have been allowed,
It should be.
you
routed
have
through the
been,
headmaster
you had
office.
enough opportunity to get it corrected.
My lord, I have submitted through headmaster for correction, my lord. This headmaster.
Well, unless it is mentioned and corrected, how the authority will provincialize your service? When one of the requirements is that your name should be in the DICE data.
Lordship. And other document also, lordship, I have page 60, my lord, where also correctly appeared, my lord. And it
Where
is.
does it say that your DICE code? Where is your DICE code or DICE? Where is your name in the DICE data?
Rice data, my lord, some wrong is there, my lord.
Then that is the crux on.
Subsequently, my lord, submitted for correction, my lord, but the authority has not corrected, my lord.
Until the time it is correct, how the authority will know? The authority will provincialize your service until it is, if you fulfill or everything, all the requirements, how you will be provincialized, how your service will be.
So in the appeal also have not given, my lord, full opportunity to.
No,
Yes.
appeal also you are heard, you have not produced any documents to show that you are your name has been wrongly mentioned, therefore it has been corrected. Puzzle hook could be someone,
Yes, my lord.
we don't know.
No, my lord, from the other record, my lord, school record, inspection report, my lord. His name appear, my lord. This, page 50.
We don't know. You first get it corrected,
So, my
then
lord,
you may have a claim. Until the time it is corrected,
is it possible to give a direction by lordship, my lord, to submit application for correction, my lord, this time?
that direction is not required.
Since my appeal already rejected, my lord,
You get it corrected and come back.
unless, my lord, liberty has not given, they will not.
See, you are saying that your name has been wrongly spelled,
Yes, my lord.
wrongly mentioned, although your
Name appear in the
ought
dice
to have
code,
been your name, not Puzzle Hawk. Should have been appeared in the dice code. Can you show that the name of the Puzzle Hawk appears in the dice data? Puzzle Hawk.
No, his.
Puzzle Hawk name is there.
No, it is, my lord, mentioned as Puzzle Hawk.
No, Puzzle Hawk name is there in the dice data.
Yes,
Where it is?
Last may kindly see page 35, my lord. Page 36, my lord. Is the dice of, my lord, 2010.
No, 2011-12. From 2011-12.
Thereafter it follow, my lord.
Where
Dice
it is?
started, is page
11-12.
Page 36, serial 7. Puzzle.
This is of 1999.
This is dice of, my lord, 2010.
What is 2011-12?
11, my lord, next, my lord, page 37. It's appear Puzzle Hawk. 38. Page 38, my lord. They also in affidavit admitted, my lord, name is there, but his name is not correct name.
What is they saying?
Page 120.
Lordship,
Database, the record is available in the year of 2006, 2007 to 2020, 2021. Please see the name of the follower is not found in the review guide also. Retained by the new database, new data. Database submitted all the and already frozen by the ministry of the visual. Be particular to mention there that the correction, authorization, and notification. These submissions are rectification and diet data for any previous year is not possible. Dice is the annual data collection process under the Ministry of Education of India and the reference that of data in 13 September every year. Dice database is submitted by the school block after proper verification and verification to the level and from the state level to the Ministry of Education of India every year. The dice database of previous years has been already frozen by the Ministry of Education of India. The system is maintained by the National Institute of Education, Training and Administration. And it is designed in such a way that once database is frozen, the system does not allow any changes, modification, correction, rectification of dice data for a year that has already elapsed.
Lordship, kindly, their affidavit, my lord. They have given the old data of my dice code, my lord, page number 120.
$120 is something different.
My lord, their affidavit, my lord.
Affidavit of respondent number 2.
Respondent number, my lord, six, one.
Ah. Pera,
My lord, page 120, lordship.
pera.
My lord, here, my lord, a chart is given, my lord. Showing the data, my lord.
Is 126. Year-wise status of teachers of Uttarakhand. Ha.
Yes, my lord. So his name appear, my lord.
Fazal Haq.
Fazal Haq.
Hmm.
Thereafter, my lord.
Fazal Haq. Fazal Haq.
Yes. Thereafter,
Not you.
Yeah.
Not you.
Fazal Haq, my lord.
It's not you. It is Fazal Haq.
Yes, that's why, my lord. I am saying that, my lord, my name has been wrongly, my lord, recorded, my lord. But that's Fazal Haq and my lord, this petitioner is one and the same person.
Yes, Bego, you have not clarified whether this claim is that his name is wrongly spelled, mentioned. There's no Fazal Haq like in the school. No, in this petition, there's, have you said so?
Yes, madam. Fazal Haq.
Fazal Haq in 2010 to 11 also.
Yes.
Huh? '13 also, Fazal Haq, 14 also. See,
No, my lord.
2015, 16 also.
My lord, may kindly see in my petition in para 4 I mentioned, my lord. May I read, my lord?
2015, 16 also is Fazal Haq is there.
In all record, his name is there, my lord, but they are.
But Fazal Haq, not the Fazul Haq.
That is incorrectly recorded in the dice code, my lord. So it is. But in other record, my lord, his name is correctly in school record. His name is also correct, my lord. In academic certificate, my lord, all are incorrect, my lord. My lord, their case is that, my lord, it is not possible now to correct it, my lord. They are not saying that, my lord, I was not.
Obviously, but then what he is saying is that the Fazal Haq is he. There's no other, the Fazal Haq is non-existence. Who will ascertain that? Who will ascertain that?
My lord, this will be ascertained by respondent number. CRCC. That is the, my lord, respondent number 5.
Who is
And 6.
respondent number 5?
5, my lord, we have made party, the National Institute of Education and Planning and Administration. And respondent number 6, the mission director, Sarva Shiksha Vision Mission, SSA, and UKI. They are maintaining the record, my lord. Respondent number 5.
Who is SSA? You are SSA. See, his case for a claim for provincial election has been rejected on the ground that his name doesn't appear in the DIC, that data. But he could show that the name of the Fazal Haq is there, which has been wrongly
Written as Fazal Haq, some
spelled. Because all along his appointment, recommendation, date of joining is Mr. Muhammad Fazlul Haq Mandal.
Yes.
And you have rejected, I mean the authority has rejected. Oh.
this authority on against that. The separate authority. Education department is not the authority of maintaining the diocese. So what is before the, education department is that this Fazal Haq Ahmed Lordship is named Mandal. Petitioner is Fazal Haq Mandal. His name
Fazlul Haq Mandal.
His name appears in the diocese data subsequent to 2009. Now they cannot rectify this mistake law.
No, what it is? Only it's up to 2015-16. His name is Fazlul Haq is there.
Yes.
Not his name.
Yes.
Nowhere there.
Lords may kindly say this is the page 120 is the affidavit filed by the SSA authority. Here, Lordship, I am saying 2019 is the relevant period of Lordship. 2019 Lordship is only Fazal Haq.
That's what I'm saying. What he's claiming is that Fazal Haq is he. There is no Fazal Haq.
Who will do that adjudication that Fazal Haq?
That's why I'm asking, who will do that? I'm just, asking a suggestion from you. Who will do it? That's what I'm saying.
Fazlul Haq and Fazlul Haq Mandal is the same person.
But then he could bring on record to show that he was a teacher whose name has been recommended. The date of joining and everything, name is Tele. Some other records. Now, when he is the appointed and recommended for the provincialization of this school, there was no other Fazlul Haq son. Now, just listen, just wait. Then would it not be appropriate to,
In that situation, regarding the issue whether Fazlul Haq and Fazlul Haq is the same person or not. Lordship is saying that this honorable court is the appropriate authority.
Not appropriate authority, but then it's a
responsibility law. Please place some document before the education department that this Fazlul Haq and this Fazlul Haq Ahmed is the same person. Restraining him to that.
While actually
a basic minimum law.
that opportunity has not been given, madam.
You approach, you get it done.
Now,
We
education
approached
department
before the-
cannot make this rectification. What is this document merely placed before the education department? And education department blindfoldedly follow this document concept, and they will only consider whether.
Who will rectify this? Who can rectify? Suppose if it's actually a mistake, inadvertent mistake. Suppose should have been my name. Your name is given, or the non-existence name is given.
Is
Madam,
in the authority is that valid laws, that this who ultimately the ultimate authority Ministry of Education. Once any UPA authority is there.
yes, that's why we made party, madam.
So ultimately, they will have to now see.
Who is that? Who is appearing for that? Anybody appears?
My understanding is very basic law.
No. See, when practically if it appears that if it is inadvertently mentioned the name of a person wrongly, then I think
These names are forwarded by the consultant school itself. These are not our creation.
no, but your school, the district school committee has given his name with the.
For the purpose of putting his name into dice data.
Who is for respondent number 5? Central government will appear. Notice has been served. Ministry of Human Resource.
That is one option. Or even without correcting the dice data. If a conclusion is placed before decision of the appropriate authority is placed before your laws report for the education department, that this Fazlul Haq and Fazlul Haq Mandal is the same person. Then I don't see any, objection raised by the education. You will not raise. But for the time being, Lordship, this is the only document, and their concern is, so far as the relevant period is concerned, 19.
Yes, maybe you are
That
correct.
is the only issue. Ultimately, this is the court of law, Lordship.
My lord, that's why, my lord, this honorable court earlier, my lord, liberty has given to approach the appropriate authority, my lord. We filed appeal, my lord, under section 14, my lord.
Where is your appeal? Have you said so? In your appeal? Where is your appeal?
Appeal.
Page 65, sir.
Page 65, my lord. My lord, page 87.
87,
Yes.
88 or 89 or appeal?
87, my lord.
Start from 87.
Yes.
What is your statement? Para 4.
Have a statement, my lord, more than specific.
That has been already in appeal, they have already filed, that has not been considered. Or else,
My lord.
he has taken the ground, page 91, in the appeal.
My simple, I don't see why should I advise it not. My simple suggestion would be lots of things should approach the civil court. Find it clear that yes, these two names belong is of the same person. There will be no objection before us. No? Only that litigation not very confusion from the court. Okay.
This impure order is of which date of order, impure order?
Appeal, page 99, my lord.
Earlier writ petition, your case has it was dismissed.
No, my lord, his liberty given to appear before the appropriate.
Yes,
And
I think he is correct. We don't know. They have gone, as I find earlier also, they have gone by the records. Because your name doesn't show. It's Fazil Haq.
My lord, earlier they have stated that.
So you avail the appropriate forum. Get yourself a declaration that this Fazil Haq is you. There is no any other person, Fazil Haq, who has appointed and all. Clear and come back. We'll grant you. We'll provide you a liberty. Otherwise, it's very difficult.
Yes, madam.
We'll go by the records.
Last time, even liberty, my lord, we approached because, my lord, his now, my lord, his age is.
Not Mr.
Jiuddin, my lord.
Huh?
Jiuddin.
Jiuddin, learned counsel for the petitioner. Who, no, just after arguing the matter at some length, Mr. Jiuddin, learned counsel for the petitioner, submits that he may be allowed to withdraw this writ petition with a liberty to approach the appropriate forum for a declaration that the name of
the petitioner.
no, the name of Fazul Haq. Fazul Haq.
Madam Fazlul Haq, Fazlul Haq Mandal and Fazal Haq.
And the name of the name
Fazlal
Fazil Haq.
Mandal.
No, Fazil Haq has been wrongly mentioned in the, what is that page?
My lord,
This thing, DIC data,
data, my lord.
page 126.
Yes, my lord. In one, it is appear Fazal Haq, then Fazal Haq. My lord,
FAZAL, HOQUE. Fazil Haq since 2006, 2007 to till 2015, 2016, in place of the petitioner, namely MD Fazlul Haq Mandal, who has been serving in the as assistant teacher
yes, my lord.
in the what is school?
School name is, my lord,
Jorsi Muli
Puran
Kuchia Emi Madrasa. Mr. You just read the sentence. Fazil Haq. Jorsi Muli Purana, page 99. Kuchia Emi Madrasa. List of Mr. G. Pegu, Learned Standing Council, Elementary, and Mr. P. Nayak, Learned Standing Council, SSA, are present. Next para. Considering that considering the claim of the petitioner as regards the inadvertent as regards the petitioner claims that the name of one Fazil Haq has been wrongly entered in the, what is it? This is DICE data.
Yes, my lord.
DICE data in place of the petitioner, namely Muhammad Fazlul Haq.
My lord,
Bundle
11 and 12 may be mentioned, my lord. They have
since 2000. Six to 2007 to 2015 to 2018. There are so many Fazlul Haq, so many people are there.
no, my lord. His name appeared,
That
my lord,
the
every year, my lord.
no, there are other names also.
No.
Fazlul Haq,
I guess
something,
my
so
school,
many Haq.
no, this is data of my school.
It's all right. I'm not on that. I'm looking at your this data.
Same school, man.
And in place of the petitioner, namely so and so, which this court would not have could not would not be in a position to decide the claim while exercising the writ jurisdiction, the prayer for withdrawal of the writ petition with a liberty to approach the appropriate forum is accepted. Accordingly, the writ petition stands closed on withdrawal with the liberty as prayed for. Please stop. The petitioner is also at liberty to approach this court if occasion arises in future, if the grievance of the petitioner is not redressed in favor of the petitioner. We're providing further liberty that so that once it is done, once you get this declaration, go back to the thing, and if they don't, then you may come back. Therefore, we're providing a further liberty, in fact, which you have not prayed.